Item 1 to 11. 12 to 22. 23 to 37.
Item 31. Matter may be compromise. Party aspirant पहुंच पाना थी आउट डेट को 10 दिन
after 2. Yeah, 31.
24 miles.
Huh?
24 miles. Come up, sir. I was out of station, my lord. So I will take instruction related to weeks after.
2 weeks. 24. Yeah.
38 to 49.
42 my lord. A compromise. Both parties have come. Both parties have come compromise matter.
What are the offenses?
372 and I'm already married.
They accused is married with.
Yes, madam.
Okay. 2 o'clock.
Oh,
50 to 65.
May I please, your lordship? Item 63, my lord. I mean, Bishi.
Yes.
The matter may taken after 3 weeks.
Taken up
3 weeks after.
3 weeks. 63, na? Yes.
Yes,
Yes.
66 to 80. 81 to 95.
92, my lord. For 90-day case, dispute has been settled, my lord. Wife is staying with the husband, my lord.
Bring them.
They are present, my lord.
I'll take it up 12 o'clock. 2 o'clock.
2 o'clock.
2 o'clock.
Well, item 88. Paper Arjun.
80.
88.
88.
Well,
Okay. On the request of
petition.
petitioner counsel.
Petition.
On that.
96 to 111. 112 to 126.
Pardon. 113 mile. My senior Mr. Das is there. On appeal is against conviction, fresh admission. 2 years conviction in a day.
I'll allow it.
My senior's name be.
Okay.
I am present through virtual before your lordship.
You are always.
Thanks to him.
130, na? Same mode.
Bail and stay realization file, both.
Bail. Yes.
Obliged, man.
Obliged.
Mr. Das, advance copy.
They search.
Yes.
They search.
Okay.
Thanks to him. Se kali coil answer.
127 to 137. 138 to 141. Item 1.
Item 1, I'm praying for Passover, your lords.
Passover.
Yes. Grateful.
Yes.
Item 2.
May please your lordship, my lord.
Yes.
The present petitioner, my lord, working as a branch manager under Jasur, my lord, in SDB Financial Service Limited, my lord. And the informant, my lord, the borrower, my lord. The officer of the present petitioner, my lord, sanction a vehicle one in his favor, my lord. Kindly glance at the informant lost this FR, my lord. Alleged that the FR has lodged, my lord, on 5/9/24, my lord, under Annexure 1, my lord.
Yes.
In the said, he stated that, my lord, while vehicle was kept in front of his house, that vehicle was stopped, my lord. This is the allegation, my lord. My humble submission, my lord, kindly glance up under Annexure 6, my lord. The Annexure 6, my lord,
You are the branch manager.
my lord,
Yes.
the Annexure 6, my lord.
He is not. He might not have paid the installment. You pick up the. That's the
Again.
story.
See, with the knowledge of the police, I may say, she's called police
The Supreme Court has, deprecated this practice.
my lord.
They pick up the.
No, in due procedure law.
What due process?
I am
Pick up the
satisfied.
vehicle. What due process?
I am satisfied, lord, my lord.
Yes.
The under Annexure Miller 6 is Miller.
I am there.
Is the pre-deposition intimation to the police officer, Miller. To the police station, Miller. And in that letter, Miller,
What is the due amount?
Miller, 41 lakhs, Miller.
1 lakh.
Not 41 lakhs.
41. Is a truck.
Again.
He's not paying.
Hmm.
Have you started any proceeding?
Yes, Miller. After starting the proceeding, Miller, I am annexed,
What
Miller,
proceeding?
the repurchase of the vehicle, Miller.
Recovery proceeding you have not.
Arbitration award achi. Arbitration award that is under Annexure 5,
Okay.
Miller.
I issue notice, but why have you not implemented the informant?
yes.
Why have you not implemented?
I am permitted to mention his name, Miller. This.
That's very important thing because we have to call him.
My lord, this is the genuine fact, my lord.
I understand it. I am-
ଆମେ ତାଙ୍କୁ notice କଲୁ ଆମର hypothesis agreement as per
Otherwise, the banks will be ruined, they will never, they will not able to recover anything. And he doesn't pay.
I'm
What
telling
is there? He doesn't pay. Installment is stopped. And they follow due process.
My lord, on
policy
8
letter and everything is there.
recall notice on 18/6/21, my lord. This is the annexer 3, my
But
lord.
you implead him, implead him.
My lord.
That, Counsel for the petitioner seeks to implead the informant, opposite party number 2, issue notice to opposite, implead opposite party.
My lord.
I have issue notice, implead immediately,
My lord.
after 2 weeks, huh? Yes, sir.
Item 3,
You may kindly be passed over.
Have you moved application for stay and all? Not move. You have not moved the application.
My lord.
You have not moved the application for stay anyway.
No, no, stage is not required, my lord. The police already given a 41 serving to the reverend.
Implead immediately, eh?
My lord.
Yes.
item 3,
Ms. 3 may pass over.
Pass over, yes.
item 4,
Why pass over, Mr.
Lalit senior Mr. Thought was appearing, he is on it right now.
item 4,
May I please, my lords? Petitioner my lord recently appointed as a Ogniver Indian Army, my lord. He is service in problem because of annexure 3 that cognizance taken, my lord. Offense under section 506, 294.
You
SC
come to the merits. You have faced a problem. Obviously, if there is a case, then you will have to.
And I'm challenging my cognizance order, my lord.
Why?
My lord, because annexure 1 FIR lodged by the sitting Sarpanch, annexure 1, my lord, page 9, my lord. My lord, here, my lord, the informant is a lady, sitting Sarpanch of the area. The allegation that petitioner along with 7 others entered into her office and abused. That is the allegation only, my lord. For which, my lord, 506, 294, 34 Indian Penal Reduced Section 3 of SC Act is there. And notice has come from headquarter of
Obviously, all these things are not relevant at all.
your case is pending, so you clear, otherwise your service.
Those things are irrelevant for
My
the
lord.
purpose of this petition.
That my lord,
If you are a Ognivir, you are supposed to fight somewhere else, not in the village. Come and threaten the Sarpanch and all.
no,
Come to the point.
my lord. And I have also added opposite party, the SC/ST Act is there, my lord. I have added opposite party number 2 informant as party, my lord.
I'll simply issue
My lord.
notice.
Simple matter, my lord, that is
Otherwise,
likely,
on merit, I can't pass.
likely, my lord, that is the chance of, my lord.
Therefore, I'm simply issuing notice. Because at least your job will be saved. Because your contact is see. In this contact, nobody will give you the.
मैं compromise करूँगा बोलो.
I simply issue notice.
ସେଟା ଭୁଲ ଲେଖି ଦେଇଛନ୍ତି ଯେ ସେଠି
Whole night, the detailed FIR.
ଆଜ୍ଞା.
And investigation has already been done. And you have done this mischief for coming to the village. In the vacation, whatever.
Along with the 7 others person, they entered into her office and I will that
Now,
is telling.
empowered. Yes, next.
My lord, in this regard, my lord, short term date, my lord, so that
2 weeks I'm giving, file the process immediately. Let him come, I'll try and settle it.
with the lordship's permission, miscase file, my lord.
How can I say, I am not interfering on merits. I'm just trying to.
ନା ଏଟା
find out a way to
ମୁଁ ସେଇଟା ଡ୍ର କରି ସେଟଲ ହେଇଗଲାଣି ଖାଲି ଜଷ୍ଟ ଆପଣ ନୋଟିସ ଗଲା
Shall I
ପରେ
record it?
This may be considered after appearance.
Yeah, otherwise how can I give it like that?
After appearance, this may be.
You bring 2 weeks, fixed date,
ଡେଟ୍ ମେ ଦେଇ ଦିଅନ୍ତୁ my lord.
fix, you
Particular
file the process immediately.
My lord, today I will file, my lord. I'm undertaking about today I will file.
Bring him at, and I'll
Aja.
ensure that.
Oblige, my lord.
Yes.
So short date.
Only to save the, and
ଆଜ୍ଞା ସେଇଟା ତ
tell your client to pay some money as a cost because of your contact. You are earning otherwise, Ognivir.
ଅଗ୍ନିବୀର କନଷ୍ଟେବଲ ଟୁ ତଳ rank.
And you are supposed to do service to the nation, not in the village.
ସେଇଟା false ଦେଇଛି ବୋଲି my lord. Obliged.
Get ready for paying some.
ଆଜ୍ଞା.
Yes. Yes.
Item number 3 was passed.
Yes.
Same method.
Which one?
item 3.
Oh, 3, yes, pass over.
Here, method the same principal method Priyanka Srivastava's case. Another complaint case was filed against another partner.
Same party, running the affair.
They will pass this order.
David Poyas.
They will step.
How to conceive this page 36, the affidavit. Is it not the affidavit?
No. Because apparently line and length have been decided in
Then
3 paragraphs. Pilot, I have got the document.
give me the judgment, Tadashi.
I have given the let me see. So I have referred it in paragraph 15.
See.
Let me see.
Let me give the interpretation.
It is to be specifically mentioned that affair was lost.
Yes.
It's there, I have stated so. Paragraph 15, page 17, which he first page, I draw my reference to the judgment. That it is to, it is respected submitted here that as per the complaint by the opposite party number 2.
No, but see, in the para 6, he says that yes, before
That is
IIC
correct
chose
format.
the
That is format. That is format in the complaint petition.
That's
Filing
right.
of a complaint petition is format. But it is to be avoided through an affidavit.
Is this
as stated.
filling
Yes.
up the format is not an averment.
That has been clarified whether it is. This document I have used in many cases. And,
No, I am just wondering, in many, almost all the cases are like this. That's the whole difficulty.
well, that has been clarified by the Honorable Justice Sahu also in one case.
Specific averment.
It is there also, but it is
I have seen it. I have seen it. There is no specific averment, but that format is there. And the affidavit is also like this.
format.
I am sole confident, so the fact stated above, and he is signing in Hindi. There is nothing.
Let it be,
He doesn't-
by lawyer after the instruction, let it be hard next week.
What to do? Almost all the complaints are like this.
Like
See,
this.
he signs in Hindi.
Yes.
See the affidavit. It is not even said that it was read over and anything of that sort.
The reasons ascribed by the apex court is that I have also stated in paragraph 15. The want for giving a judicial direction, the application number 156(3) is supported by an affidavit in order to ensure that the person making the application should be concerned and also endeavor to see that no false allegations or statements are
That's the
made.
whole idea.
That was the
Same one.
intention.
Same what to put. Yes. And you just note it down. Similar cases, wherever I have issued notice, tag kar deta hai.
Both the cases have been
Take
tagged.
karo. And let us decide this issue.
Correct.
Otherwise, see, in Orissa, the kind of affidavits are being filed. Almost all the complaints in 156(3) has to be quashed. If stricto sensu, you apply a Priyanka Seva.
Spirit.
That's the problem. The affidavits are very casually
Reference करता हूँ.
drafted and nothing is there.
Criminal miscase number 641 of 2000.
Yes.
2000.
Yes.
Item 5.
May I please proceed? So petition challenging the order of the order 4/11/2022, the cognizance order of initial the FIR registered under section 379 294 of IPC lordship. But subsequently, charge has been filed 379 294 420 468 and 413, and the lawyer must have taken the cognizance of the same. But so there is no material available 294 420 460 413 against me. I am only have in the part of the stolen of the article lordship in the theft case. The allegation is primarily against Bikram Naik, and the stolen article has been given to the accused from the West Bengal. So I have no way connected to the receiver of the stolen article. The mechanically lawyer magistrate can
Come to the charge sheet. What are the allegations?
Yes.
Just see.
page 13 lordship. That's fine.
At page.
Come to page 31.
Most of the news.
Second is I am the petitioner, the second column. Muhammad Abu Nasser.
Actually relating to in charge sheet.
She's 19 numbers of
The material in the charge sheet.
theft. So गाड़ी का चोरी
That is good. I will recognize it for it. Mahmoud Abu Nasir.
What is the allegation? Anybody can tell me, or I'll have to read and decide. Tell me the
Mr.
allegation.
Place 32, Lordship. The accused person is Montu Juma Sonu. We are discussing about the selling of a truck with help of one Ramesh Polida who runs one rugged
It was sold to you.
and regular seller of the trucks.
It was sold to you. Yes. I got it. Yes.
It was,
Yes.
it was sold to
Cognizance. What is
Ajay-
wrong in cognizance?
Also, the admitted that the receivers, namely Ajay Kumar Saw, son of so and Abhijit Saw, both are of BT Road, PS in the Kolkata Lordship. They are the receivers.
Money is recovered, 2,45,000 is recovered from you, and you are one of the conspirators. That's the allegation.
Yes.
And the statement under 161
What's
also there against you. You argue at the stage of framing of charges, right? Petitioner is assailing the order dated 4/11/2022, passed by Lieutenant JMFC Chandigarh in city case number 1412 of 2022, whereby cognizance of offences punishable under section punishable under section 379, 294, 120B, 420, 468, and 313 has been taken against the petitioner and 8 others co-accused persons. The perusal of the charge sheet reveals that perusal of charge sheet and the document form part of the charge sheet reveals prima facie case against the petitioner. Hence, no interference at the stage of cognizance is called for. However, petitioner is granted liberty to move appropriate application before the trial court, seeking appropriate relief at the appropriate stage. If such application is moved, the same shall be considered on its merit. Yes, next.
Obligations.
Item 6.
Yes. 6. Only, yes. Pass over.
Item 7.
May I please your lordship?
Yes.
My lord, this present application has been filed under section 482 of CRPC for quashing of the impugned order of cognizance
Yes.
taken under section 285-304A of IPC against the petitioner.
Yes.
My lord, I am the government servant and working as a senior section engineer under the electric department of Southeastern Railway at Bandamunda. My lord, the unfortunate incident happened due to heavy rain and storm. Some electric wire.
Come to the allegation part.
Yes, sir, there is.
What are the allegations against you? What are the materials? Because you are challenging cognizance order. Let us see.
Yeah. Well, I am challenging the cognizing order on the ground that it is not tenable in the eye of law because no sanction has been obtained while taking the cognizance against me, against the offense under section 285 and 304 of A of IPC. My lord, the negligence act attributed to me.
What are the allegations?
Yes, my lord.
Yes.
Page 30,
Hmm.
charge sheet.
Yes.
During inquiry, it is ascertained that the complainant Raju Parmanik is a railway employee working in the AC railway department and staying in the railway quarter. That is quarter number such and such, which is situated in sector A. This is Abhishek Parmanik, is the son of the complainant, on dated 21/8/22 at 6:10 a.m. morning. He went to the working hours nearby quarter some days before due to heavy rain and storm. Some of the electric wires from the electric force are laid down on the ground in between. One wire laid down in the flower trees which is situated in front of the house of the complainant. While this is trying to blocking flower by the iron rod, unfortunately, it came contact in the electric wire and
He's the engineer.
Yes.
He's responsible. That's what.
Yes.
Yes.
So, my lord, my name has not been mentioned in the FIR. I was not present at the spot. So, being the
And if you notice, because see,
But
there was a storm
yes,
and the heavy rain was there.
so it is
So anything might have taken place, nobody knows it. And what are the materials? Nothing is there. Okay, you notice.
nothing is there because only on the confessional statement.
party,
I just issued, yeah. Take it up. What are the materials?
included party,
Huh?
OP2 is to be included.
The informant is not made party. This is the usual practice here. Let it be noted. We'll have a counsel for the or increase, huh? Okay, the party is the informant. So we need to next, yes.
Item 8.
Order of framing charge, my lord. In annexure 2 at page 12 is under challenge. Offences under section not under which the charge is framed is 376.
This is against charge.
Charge, my lord.
Yes.
4376, 493, 471 RPC against person number 1. And so far as 506 is
Where is the order? Where is the order of charge?
as annexure 2 as page 12.
12. Okay.
Lordship. And the ordering person is at page 15. The father and son is the accused.
376, 496, 417. So,
The fact of the case is that, my lord, so far as the
where is
allegation
the
is
charge
Not
sheet?
charge
Let us see the charge sheet.
That is not filed.
charge sheet copy ଟା ମୁଁ ଦେଇ ମୋ ପାଖରେ ଅଛି, lordship can have a glance to that. I have not filed it because
Except FIR, you have not filed anything.
no, the rejection order, it's a copy of the charge sheet.
Rejection order. How will I know rejection
No,
order?
in fact,
What
my
is
lord,
the charge?
The copy of
Charge
the
has
charge
been
sheet,
framed.
the copy of the charge sheet, my lord, which I am possessing, there is of this condition. If I file it, my lord, then the defect will
What
be
can I
pointed
do?
out.
Can I, how can I, see, only reading the FIR, can I watch the charge order?
No.
Lordship can have a glance to that, etc. Because
See, you have to place it on record. You are challenging the order of framing charge.
the charge is
Charge
under,
sheet is not there.
charge is under section 493, 417 and 5069. Is a case of peculiarity of the case is that a case of
Okay,
dieting.
I can understand, but I need to know what is the, you have to see the charge sheet.
Yes, madam.
That I am ready
The
to file,
order of
my lord,
framing
because
of charges,
because the
the charge
problem
sheet is
is-
not
because
there.
the problem is that, my lord, that the condition, the
Whatever may be the problem, what can I do?
defect गुड़ाक remove
आप
करके
कौन-
हमको तो list को आसी परिबो या the
ହେଲେ
case is
କଣ
closed.
କଣ କରିବା କୁହନ୍ତୁ ଆପଣଙ୍କର ଖାଲି ଗୋଟେ FIR ଫାଇଲ କରୁଛନ୍ତି
And
ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି ଫ୍ରେମିଂ ଅଫ ଚାର୍ଜ
I will
ମୁଁ FIR ପଢିକି ଚାର୍ଜ ଅର୍ଡର ଟାକୁ ଡିସାଇଡ୍ କରିବି
now here my only solution is can I have a glance to that, my lord. I am having the copy.
Don't
having the copy.
make it so apparent. They don't do it. Our try question, what can I do?
Take time. file the copy.
If it is not legible, 207, you can tell the prosecutor to type it and give it because you can't read it. That's the law. Have you done it?
I am not
You
drawing, my
accepted
lord,
the charge sheet, which is not legible at all, and went ahead arguing the charge and got a charge framed against you.
The informant is not included also.
but why should I be? It's a GR case.
May not be.
The
That is-
informant
that is- But you have to place on record the charge sheet. Otherwise, how the court will decide? Suppose today I will decide in your favor by reading it. Tomorrow somebody will challenge. What will happen? On the basis of reading FIR, I quash the charge order.
No, if a lawsuit, if a lawsuit permit, will not, I will fail. I will file it.
You file
But
it.
in fact, will not.
You bring it on record. We'll see. After 2 weeks, huh? Let him bring it.
In fact, the case is posted today, my lord.
I can't help it. See,
So that I do understand.
see, this matter would not have been listed. It is on because of my effort. The matters are
Lordship,
listed.
that I do understand, my lord, because the problem is that, my lord, because of this SR.
Because I said all the matters which are not listed once also you list all these. 140 matters I'm listing today. It is not because of your effort the matter is coming. It is because of court's effort is coming. Yes. You don't file the documents. What to do? Then counsel for the procedure seeks 1 week time to place on record the copy of the charge sheet. Let me do so within a week. Leave the matter in chapter 1. Okay. You manage it. Yes.
Next week, the matter will come.
No, next week. Please type it and file it so that we can. And why don't you move an application? In 207, you could have moved an application saying that the
I will
copy which you have supplied is completely not legible. Supply the right copy and Just see, Mr. Ragada will tell you.
Time
difficult almost because
I have seen these documents are not at all legible. But it is the responsibility of the police. They type it out and give you.
Exactly.
And casually, whatever they supply, you take your lawyer who is appearing. They casually they take it. Thereafter, when it comes to High Court, then you are facing problem. This is the reality.
that I do not
They
understand.
send the junior. Entire bunch is given to you. You bring it and accept it. Sign receive it.
Mr. Tripathi competent.
Actually, there and then you have to see which pages are not legible. You have to give a slip that these are the pages not legible. You supply the legible copy. This is a big exercise. This is never done.
Much more experience in this line, madam. He is
that's right.
working under Mr. Popular Dhar, my lord. Criminal appeal matters he is doing.
So who can teach you more than? Yes.
9.
9 my lord permitted to us argue on behalf of Mr. Sivaranjan Pillai, my lord. 3 cases, 9, 10, 11.
Yes.
Here, my lord, challenge the order dated 28/11/24 at page 51, my lord. What happened, my lord? Actually, my lord, the petitioner filed a complaint case against the opposite party number 2, my lord. There, my lord, the petitioner, the opposite party 2 appear in that case, my lord. File 205 petition, 130 act, my lord. 30 lakhs involved in this case. File 205. Evidence recorded. And then, my lord, the case adjourned for accused statement. He did not, my lord, come. The advocate took time for 3 times, my lord. The representative lawyer for the accused, my lord.
So show me that order. 51, page 51.
Prior to that, my lord, page 51. Prior to that, my lord.
Accused person is absent. NVW.
Took time, my lord. Since, my lord, page 46, my lord. And prior to that, my lord. Page 45. 45, my lord. Learned counsel for the parties are present and file hazira. The learned counsel for the accused. 205 is allowed, my lord. Files time for ground stated therein. But like that, my lord, from January till, my lord, 18/6/2024, my lord, page 48, time allowed for accused statement, my lord. Thereafter, my lord, NBW issued against him. And when the advocate concerned advocate who has filed 205 representing the accused, he has not appeared. For that reason, NBW issued. Thereafter, the
you are the complaint.
Thereafter, my lord, prayer made by the complaint.
Simple. Come to this point. Page 51.
If
NBW is issued,
my lord,
you can't execute it.
no, my lord.
The police has to do it.
Giving one date, my lord, issued rightly 80-83 process issued, my lord.
Yes.
See, NBW was issued against the accused persons. It is not executed. 82-83 process initiated.
Exactly.
The court is closing it, saying that
Sending dormant.
there is no question of apprehension. Then what the complainant will do? Private complaint. He is depending upon the police machinery. Police will not execute the NBW. Therefore, his complaint is dismissed.
Exactly. Send the file to dormant, my lord.
Even if it is sent to dormant,
Under the
police is also empowered.
only because see that is the reason I tell you. It is written like the Honorable High Court has targeted it.
Exactly.
To target the case. This is the pressure on the
Target, my lord, out of court I mentioned, my lord, magistrate has much more, my lord, other remedies, my lord. He can send the reminder to the SP and he directly IAC to execute, my lord.
I'll give that direction. Right. Petitioner is agreed by the order dated 28/11/2024 passed by JMFC. Which area is this? JMFC? Chhatrapur, whereby the complaint case initiated by the present petitioner against the opposite party under section 138 NI Act has been sent to has been closed, and the file record of the case has been sent to a dormant file as the rule 326 of GR NGO Criminal Volume 1. The impugn order reads as under. Impugn order go to page 51. It appears that NBW was issued against the opposite party accused on NBW
Invitation, my lord,
on certain day, and the NBW could not be executed.
18/6/24.
18/6/24.
18/6/24.
Could not be executed. Therefore, the process under section 82-83 was issued against the opposite party. When the matter was taken up for final hearing, matter was taken up on 28/11/2024. The trial court records, trial court formed the opinion that there is no chance of early apprehension of the accused person and accused person, and this court has already targeted the matter to be concluded expeditiously. Hence, the magistrate felt it appropriate, deemed it appropriate to close the file and send it to dormant. Please the record on dormant files. It is Mr. Raghunath, learned counsel for the petitioner, submits that execution of NBW issued by the court is not under the control of the present petitioner. It is the complete failure on the part of the police machinery. But for non-execution of NBW, the complaint filed by the petitioner could not have been dismissed. The submission of Mr. Raghunath deserves merit. Therefore, I set aside the order dated 28/11/2024, restored the complaint case.
Dormant to police khali. Dismissing dormant to police, dormant to
call for the restore the ICC case number
12/2019
to its file and direct the magistrate to proceed with the matter in accordance with the law. Since the NBW issued by the court below, dated NBW dated
18/6/24
2004, has not been executed. The IIC, which police station?
Executive court is Chhatrapur.
Hey,
Accused is residing at Bhubaneswar.
magistrate can direct Interpol also my lord to execute individual. That is magistrate has everything.
IIC, which police station? Residence?
I said that. Oh, the one.
IIC, which police station?
I see.
Bhubaneswar, na? IIC?
Lingaraj PS.
Huh?
Lingaraj PS, Olton. One sir, Lingaraj PS.
IIC Lingaraj.
Lingaraj PS.
Lingaraj police station is directed to execute the NBW issued against opposite party number 2, who is stated to be residing at Lingaraj
Under Lingaraj.
under the Lingaraj police station.
Commissioner Police Bhubaneswar.
Sir. The trial court shall pass appropriate order in that direction. Yes.
10 and 11 my lord, same accused, complaint defense, date khal defense.
Complaint follow.
Acha, sab achi.
Yes.
Up to 11.
Yes.
Item 12.
Oblige.
Your Lordship, the present petition has been filed seeking the quashing of the OHRC case number 1584 of 2024, which has been registered and initiated by the Odisha Human Rights Commission without jurisdiction and in contravention of the provisions of the Protection of Human Rights Act 1993. Your Lordship, the present case concerned the release of a vehicle that was involved in an accident.
The OHRC matter, is it with assignment? OHRC matter.
It's assigned to when? What are you?
OHRC. Odisha Human Rights Commission.
Huh? I'll issue notice, let us see. Please note. No, it is for it.
Matter challenging the order of the Human Rights Commission.
Your
So
Lordship,
it is not maintainable.
Your Lordship, we are not challenging any
This is not
order.
some criminal case, it seems. Let us see what are the
Yes.
proceedings. Let us see.
Your Lordship, we are not challenging any order.
Initiation of the proceeding.
Yes, Your Lordship, we are challenging we are seeking the quashing of the proceeding because there is no jurisdiction of OHRC to
Then
regis-
madam, you have to resort to some other remedies.
Forestry is not kind of, is not a criminal prosecution.
Who are the parties here? Human Rights Commission. Just check it up and tell me. I'll just check it up and tell you.
Yes.
Otherwise, I'll issue
Sir,
notice.
personally advised to place on the ground of maintenance in the next date.
Simply then go after 1 week. Yes. Isn't it? It is our answer. I'll issue notice. Let us
Yes,
see.
yes,
about it.
yes.
Simply issue notice. See. Yes. Item 13.
Oh, bless.
In 138 NI Act, my lord, directed to pay the 20% of the check amount. But inadvertently, in the said order, it has not been mentioned in which court the petitioner will deposit the 20% amount and in the which mode. That is, for this, I filed this IA.
Notification.
IA number 828/25.
No, you have to deposit 20%, na?
20%. That's a
20% of
court deposit or more corner. Check reki draft.
the order dated 19/2/2025. This court directed the petitioner to deposit 20% of the check amount while referring the matter for 2 million. The present application is moved for modification of the order, as there is no indication in the order as to where the 20% of the check amount is to be deposited. Let the petitioner deposit 20% of the check amount before this court. Before this court. Before in the registry of this
Check,
court.
check na draft.
Draft.
Lordship,
Lordship, I am appearing online for the petitioner, your Lordship. Lordship, this is a case, Lordship. I have filed a questioning petition for questioning an FIR, which has been filed as a counter blast by the father-in-law of the petitioner number 1, your Lordship. First, the petitioner has filed a case in that place as her child died due to negligence of her husband. Thereafter, she came back to Delhi, where she has initiated cases, and now it is pending in Delhi. Lordship, the sections are only 323, 341, 294, 506, 34. So just to create pressure upon the wife, upon the petitioner number 1, that this FIR has been filed on the instant of the husband.
Where is that FIR? Which
Annexure A5. Page
Annexure
69.
5?
Page
Yes.
69.
Yes. This is the notice, 160 notice.
Yes, sir. Contents are there, and at page 69 there is FIR.
Where is the FIR?
Page 69. 69.
69.
Yes.
Yes. What is this case? Investigation is going on.
Yes, yes.
What happened?
Lordship, we have filed the anticipatory bail application. The court has passed the dispose of my petition by saying that 41 should be complied. Nothing. Still stays in investigation.
So now investigation is going on.
Now the thing is that that's why I have filed that questioning of this case. Your Lordship, the problem
So
is that
why should it be quashed at this stage when the investigation is going on?
Lordship, this has been filed just to create by misusing the process of law. No case has happened. Even if you Lordship may see my medical report,
Let the police investigate it. Then only everything will come to light.
But your Lordship, I am a lady. I am residing in Delhi, and there is apprehension of my death in that place. If the police will call me, I will suffer. That's why. And see the medical report. How I suffer.
Merely because you are staying in Delhi doesn't mean that the cases will be passed like this.
Can you see the annexure P1, the medical report?
P1.
Yes.
Yes.
At that point of time, Lordship, this is the medical report. How I have been treated by the opposite parties, your Lordship.
So those things are not the material for the consideration at this stage.
Father-in-law is taking the
Personal difficulty, whatever, but is that a ground for quashing an FIR like this?
But the thing is that, Lordship, and the first instance FIR was not lodged. After incident happened in September 2023 and FIR was lodged in May 2024. See the difference, Your Lordship. This is a bogus FIR. That's why this is my ground. No such incident has happened. It is just a way to create pressure upon me. Nothing else.
How am I the investigating officer? How will I arrive at that conclusion?
That's why, Lordship, I am requesting Lordship may issue notice and get the a report from the concerned officer. Then Lordship may decide it. But the problem with me is
that the matrimonial dispute matter was transferred from Kemjhor to Supreme to the Delhi High Court. So this is the plea. Now on that basis, since the matter now has been transferred to Delhi, so this matter should not remain here. This is the.
I know, I understand.
That is.
Lordship, I'm not saying for on that ground that my matter has been transferred to Delhi. That's why it transferred this request.
Yes, the investigation to continue. Investigation to continue.
Investigation has to continue. How can I interfere at this stage?
Lordship, there are so many judgments of the Honorable Apex Court.
You give one judgment.
Situations in such
Out too many judgment, you give one judgment where at this stage, at the nascent stage of investigation, the 482 court will interfere.
At this stage or later, who will suffer? The petitioner, who is wife of the
You produce the judgment. Leach
Yes,
it up. Leach it up. Yes, I am not with you, but leach it up to it. We'll see.
Much obliged.
Item 50.
But IA was filed for the change of nomenclature to CRLMC to CRLMA. I'm flagging. Let's me allow.
Why? The nomenclature is to be changed?
CRLMC to CRLM.
Why? What are you challenging? Stamp reporter has pointed out.
Yes, sir.
Okay. For the stated in the application is allowed. The nomenclature of the present petition we change to CRLM, which is directed to renumber and place it before that will clear. Yes.
In matter to Hon'Ble High Court has granted bail subject to some conditions. That condition has not been fulfilled, but bail has
Which
been
one?
granted. That is.
CRLM will let it come. Yes.
60.
In this case, the court filed this case against the petitioners. They arose from the land dispute. This is a bounded tenant dispute also. And thereafter, when finally after the case, he withdrew the made application to the police, and I am not further lead the case. And the police did not consider the case and execute the case. Thereafter, they should file a complaint. There is a compromise person. There is a compromise between both the parties. And there is a activity also. They are filing. Now, there is not to their case.
Yes, they settle.
Annexure 3, the annexure Chukki agreement is in file between the informant and the present petitioner.
I'll issue notice, let us.
Yes, sir.
Issue notice to opposite party number 2. Yes. Next. Right.
70.
He'll give.
My pleasure. 17. I am the husband. Petitioner is the husband before the lordship. Your lordship, I will draw your lordship's attention at the page 34. The judgment, the decree of divorce granted in my favor.
What are you seeking?
I seek passing of execution proceedings because
execution proceeding arising out
of the order passed in the maintenance case at the instant of wife. Now it is held in my divorce case. Your lordship, see the page 34. 34.
Yes.
Para 17.
Yes.
Since divorce is allowed, the maintenance as permanent alimony needs to be considered, but the respondent wife has not specifically pleaded regarding such relief as she is an advocate and her identity card and experience certificate issued by the Bar Association Jajpur prove that she has source of income. The document relied upon by marked that exhibit D1 is beyond the context of his pleading.
How
and
can
therefore-
an execution petition be?
Yes, but I am
What?
coming to that.
You challenge that
No.
maintenance order.
I am not.
If the maintenance order stands, execution has to go on. You challenge that maintenance order. You say that it is not entitled to whatever.
Maintenance order of the year 2016. No, Lordship, I am coming to that. My wife is an advocate of that bar. My father-in-law is an advocate clerk of that bar.
I understand.
Can you understand my predicament? I have
Your predicament is confronted with the.
I have been suffering. I have been humiliated since since 1 decade. Man, she is not coming to any conclusion. Not coming for any
I
settlement.
understand it. The problem with you is today there is an 125 maintenance order.
Yes, yes,
He is pressing for execution.
yes.
Okay.
One after another.
1 minute. Execution is pending.
Yes.
Meanwhile, you file the divorce petition. Divorce court says that she is not entitled to maintenance, whatever.
Yes.
What is the remedy?
Still,
Still, the maintenance order which has already been passed,
Yes.
you have to get it passed. The execution proceeding is a consequential proceeding.
Yes, I know. I am very much conscious
If
of
that order stands, execution order cannot be passed. You have to get that maintenance order passed.
Yes, yes. My humble submission before your lordship, let them.
What will happen? Suppose I'll pass the execution. What will happen to the
I don't actually I don't pray for quashing of it. Let them appear in person so that
okay, I'll issue notice then.
Yes.
I'll issue notice.
Notice and
But you should have prayed something else.
Yes, yes. One RPFM is pending against that.
Why are you not challenging that 125 order?
Of the year 2016.
Maybe
That is my
I'll
predicament.
tell you this technicality will come in your way. You file another petition, get it tagged with this.
Yes, yes. I will file.
So that at least you can
Till then,
I'll just issue notice, meanwhile do whatever you want.
yes. In I may be permitted to seek an adjournment petition. In all the execution proceedings, because NBW in all the proceedings NBW has been issued. That may not be executed till.
No, where is that? Where have we said that?
Yes.
Petition is in fact not made.
I have filed.
Let us do one thing.
Okay, so enter order sheet I have filed in execution proceeding.
Can you please hear me?
Yes.
This petition itself is not maintainable. I can't pass it. File a proper petition so that I can pass some order. The moment, see, both of them are lawyers. If I pass a wrong order here, they'll go somewhere else. Get a stay. What will you get? It is not a common litigant. Try to appeal. So, file a proper petition. Challenge that 125 proceeding, there I'll stay. That is a better idea. I'll just issue notice. Otherwise, the moment I pass this order, this is an illegal order.
Yes. I'll.
And you say that your wife is a lawyer and father-in-law is a lawyer, everybody is a lawyer. Then they can identify what is the wrong order, what is the right order.
Yes.
Why are you inviting?
Because since a decade, when no settlement is because of their profession, they are not coming to any settlement.
You have chosen.
I have been suffering.
Who has chosen to marry?
That at that time the family arrangement was.
What to do? Yes. File a proper.
I may be permitted till that I will file the adjournment petition.
No, you file the proper petition.
Yes.
I'll tell you. File the proper petition. Proper order will be passed. Yes.
18.
May please your lordship, my lord, the matter pertains to maintenance of my mother, my lord. My lord, with my self-consciousness, my lord, my humbly say, my lord, paradise is my mother's, beneath my mother's feet.
You don't want to maintain your mother.
My lord, I am being, my lord, one thing, my lord, due to family dissension, I have been set apart from my family. And my mother and my younger brother, they are staying in the parental home and they
I seriously disputed, my lord.
But my, of the record, I'm saying about mediation.
The mother is staying 3 kilometers away and the brother is now a beggar. His total, my lord, your lordship kindly.
So let us sit together.
Your lordship.
Let
the opposite party number 2.
Yes.
He become beggar after engaging you.
No, my lord, not engaging me, my lord. I have no, my lord.
Why are you
My
making
lord, I have given 1,000 rupees, my lord, to the mother.
both the brothers,
What I'm saying.
you and your client and his client are fighting at the cost
No,
of the
no,
mother?
no, my lord, no.
As simple as that.
No, my lord.
They are
This is
sitting
not correct.
together, my lord.
My lord,
Sitting together.
And only for the property.
My lord,
Why I am saying.
so let us forget the dissension, let us sit together.
Mother.
Let the-
My lord, 1,000
Lord-
rupees. And my lord, one person, my clerk went to Badampati and.
I admitted is my righteous
You
duty and
got-
I admitted. I have already
This
said
is
it,
the
I
problem.
admitted, I'm
So
not.
then what do you want now?
Then let us sit together, it is a family dissension, it can be resolved with, if they sit together in the mediation.
My lord-
Only one, then
Here,
they
my
let
lord-
them come back.
My lord,
This is my
He
proposal.
con- he concedes what,
my lord, what I am saying, my lord. So far as, my lord, sitting together, if your lordship say my London senior, my lord, I will accompany my lord with him, my lord, to the village or whatever.
Fair enough.
Because the party will not.
Any,
fair enough.
I will be on the.
for arriving at conclusion.
Because it is
Yes,
profession.
Listen,
yes.
I'll list it on third.
Yes.
Both of you go and sort it out and come and tell me.
My lord, that may.
See, do some service.
I have
Pardon.
already.
It is that already, question is righteous duty, is my duty. So,
I have seen my lord, such a my lord,
Yes.
difficulty my lord with me, my lord, that's why I am praying.
Therefore, he's saying it's personal. knowledge.
Again.
He
Even
cannot
ମୁଁ
tell-
ସାନଭାଇ କହିଥିଲି
will not misrepresent.
ଗାଁକୁ ଯିବା
ଗାଁକୁ ଯାଇକି ଆଜ୍ଞା ମୁଁ ବତେଇବି।
ଏଇଠି ଆସ
Vacation is a-
ହାଇକୋର୍ଟ ମେଡିସିନ ତ ସବୁ
My lord, ଆସିବ
ହେଲା ଠିକ ଗାଁକୁ ଯିବା
ପଇସା ଦବାକୁ ପଡିବ।
yes yes
କିଛି problem ନାହିଁ।
Mr.
ମୁଁ ସେଦିନ ତା ମା ଆସିଥିଲା ଯୋଉ
I'll bear the 2 and 4 cost miller in this
Jointly submits that in view of the particular facts of the case. And we
That's on election.
fact that the petitioner is the son of the opposite party number one and brother of the opposite party number two. Both the councils would make their endeavors to reach their respective councils and settle the dispute and report to this court on 3rd of
ଥାର୍ଡ ବା କେମିତି difficulty ହବ ମୋର ଇଲେକ୍ସନ ଅଛି।
When?
My lord 7 to 11 your lordship.
Okay,
please,
7. I will not delay. 7.
Okay.
7. Please try.
Yes,
my lord.
yes.
11 do.
My lord, I will leave.
their duty yes
It is our my lord property.
7th you persuade them and
My lord.
yes ma'am.
yes.
19. And your lordship also direct my learning to court.
He will go. He will go.
I already I abide by lordship I don't know
What he says, both of
I
you
will-
go in one vehicle.
Man,
Do it. Yes.
May I please, your lordship? The petitioner has filed this criminal miscase for quashing of the proceeding on the ground of compromise. Offense under section 109 of BNS. Kindly see, come to lordship page 2.
Only 109.
307 and other alleged offences, your lordship. My learned friend has
109
filed charge sheet,
PNS.
Flat C.
Acho.
Flat C in the charge sheet.
109 BNA.
And other
That is
offense
307.
307. Corresponding offense is 307. Kindly come to the page 15 minor injury report. Kindly see.
15.
Kindly 15. Page
Yes.
15 annex 2.
Yes.
Injury the Ganapat Sahu. And come to the next page.
Head injury.
Yeah.
Other part of the body.
One
The assault by Rajesh Rai. Yadav.
Kindly see the injury report.
Azad and Neeraj.
One knee, simple, recti forearm.
What are the weapon used?
right forearm
Right forearm.
Okay, it's all right. Simple.
Simple.
Everything is
The
good.
injuries are simple.
But what are the weapon used?
Weapon iron pipe. Allegation of the FIR assaulted by iron pipe. Let's see. Infant has appeared in this case.
Informed might be appeared. Where is the charge sheet?
Charge sheet I filed flag C, my lord.
Yes,
Flat C.
Flag C.
Let's see. Let's see. You are Rajnish Rai. What about the other accused persons?
Other accused person got bail, my lord.
You are seeking quashing. I am not talking about bail. Are you seeking bail here?
No, I am seeking for quashing.
And then
I am filed for one accused person.
what about the other accused?
Other
You selectively settling the dispute.
No, it
First principal accused, thereafter the other.
no. Other accused person mo pakhre na.
Settlement means the full
Other
settlement.
accused person,
The informant doesn't have the choice of selecting accused.
I am settling for the
I'll
all.
settle with X, I'll not settle with Y. There are 5 accused, either is settled or no settle. Decided. That's
Settling
not
for
be
the
done.
all, my lord.
This is the very bad trend of,
Yes, I take
he
it.
will implicate, suppose, imagine if he can implicate 10 people, পয়সা নেই কি জন করে আসবো।
No, no, more
There is a business of extortion.
Keep this matter.
Either he has to settle the dispute
Yes,
fully or
yes,
not.
yes. Keep this matter.
Decide. Simply, adjourn it.
I'll done any other day, my lord.
You can't leave it to the, if she says that, for a spur of a moment, I filed it because of misunderstanding.
But I am happy for the informant.
Then it is equally applicable to others also.
Yes,
Why should they suffer?
yes, I will take against him.
20.
Pass over.
21.
I pray for an adjournment.
22.
My lord, 22 is the petitioners are the ladies members. There is a case and counter case. And petitioner number 1 is a senior citizen and a widow, and two is a physical handicap, and 3 is also a widow, my lord. Ladies member, and they have been implicated in a case. The FIR is annexure 1, my lord, and counter FIR annexure 2, my lord. And the statement of the injured, my
What are
lord.
the injury?
My lord.
Injuries.
Injury report is annexure 3, my lord. The Subhasini Ponda sustained simple injury, and Rupa Sindhu Prajabandhu Ponda sustained grievance injury, my lord. That is grievance lekha is.
No, grievous.
My lord. And the specific allegation is against the Sanjay Kumar Ponda, my lord. So far the assault part is concerned, my lord, Sanjay Kumar Ponda, my lord. My lord, Brajabandhu Ponda, kindly see the statement 161 statement is annexure 4, my lord. Page 24, my lord. Sanjay Ponda, there is a land dispute between them. Deढ़ मास ହେଲା ଘର ବାଡିକୁ ନେଇ ବିବାଦ ଲାଗିଛି। थाना फांडी भद्रक संजय पंडा मानु ना तेणु ता एति तारिखरे मो जगह से घर कांथ तैयारी करथिले संजय पंडा झुना पंडा निरूपमा मानिनी पंडा हत्या करिबा हाथ हत्यार धरी
मात्र आम्भे प्रतिवाद करिबारु संजय पंडा कुन्ना पंडा निरूपमा पंडा मानिनी पंडा हातरे हाथ हत्यार धरी आम मानकु गाली गलौज धमक देई कोन
हाथ हत्यार My lord, thereafter quoted page 25.
Yes.
संजय पंडा मो स्वामी ब्रजबंध पंडा को धरिथिया फारसरे गोटिए सत्य प्रहार देला।
You want me to read only this line? Leave all the line.
My lord, 25.
I'm reading there. Page 24.
My lord.
How will you get over this?
My lord, so far as the assault part is concerned, that is page 25.
That see 120p 34 and everything is there. Will that decide?
সেটা লেখা আছে সঞ্জয় পণ্ডা
allegation is very খଣ୍ଡা ଭାଷାରେ
ସଞ୍ଜୟ ପଣ୍ଡା ମୋ ସ୍ୱାମୀକୁ ବ୍ରଜବନ୍ଧୁ ପଣ୍ଡାକୁ ଧରିଥିବା
34 is there. Under the aid of 34, you have been implicated, you were armed, and you also attacked. That is the story.
Actually, the ladies members are the
lady member.
One is a senior citizen.
Specific name taken by the witnesses. All the names. Nirupama Panda and Junu Panda, Manini Panda, very specific names. Then?
কিন্তু 307 made out of 307. My lord, I pray for surrender and religion.
Come to that point. Why are you unnecessarily wasting time? Have you approached this court already?
Yes,
your bail application rejected.
Rejected.
Then that also I can't do. You have already burned your fingers. Burn your fingers.
My lord, surrender.
Show me that order at least. What is the terms of that order? Rejection order?
Next week.
No, next week. This is frivolous.
No.
Right on. Next.
Tomorrow.
Petitioner is seeking quashing of the petitioners are
Tomorrow.
seeking quashing of the FIR number so and so.
Second half none.
Also, allegation is the petitioner. After investigation, charge sheet has been filed in the present case. When the charge sheet is filed, present case.
Charge sheet.
Charge sheet has been filed. For the statement for the witnesses, particularly the injured witnesses, recorded under 161 CRPC, coupled with the medical evidence reveals that the victim, the injured, has received grievous, simple as well as grievous injuries and on the head and the other body parts. The learned counsel for the petitioner submits that the petitioners are lady members and they have not participated in the offense and the offense. However, the statement is contradictory to the evidence that are brought on record. Hence, I am not inclined to endorse it. This is petitioner submits that the bail application of the petitioner has already
By the bill number 6837 of 2023.
6837 of 2023. By the order dated?
That order was.
Dated?
Order.
Dated by the coordinate bench by the order dated 2/8/2020. Executed bail application 2/8/2020. He on instruction he submits that his client will be correctly opinion of the court on before 20th of April and report to the remedy available to submit. Subject to 20th April, you go and surrender. Yes.
23. Maybe please, challenging the order dated.
When for the petition to move application for grant of bail, all the points, we listen to the points arranged in the present release. If such application is moved, the same shall be changed around the bail. Yes. Yes. Yes, sir.
Challenging the order dated 37/2024, madam. Annexure 1, 37/2004, 24.
Yes.
In rejecting the application filed by the PP, public prosecutor, to examine some of the witnesses, madam, under section 311. I am the informant.
You should notice to the accused.
Here is the case. The present.
Let us accused has to be heard.
Yes, that's my. I am not disputing, Lordship. Here is the case. Present petitioner is the in front of the present petitioner, Lordship. Though 6 for example, 4 witnesses, Lordship.
You simply tell me, are you aggrieved or not?
Lordship, they have not charged sheeted, Lordship. That witness not been charged sheeted.
Are you aggrieved by this order or not?
Lordship, that I am.
Yes. PP has filed.
Let us understand. He is the informant.
Yes. Then
your
the
application has been turned down. He is coming. And
in the instance of the PP has been filed, that petition is 311.
means you.
Yes, that's right. I am not.
And you simply say that I am with you.
Yes, Lordship.
Because you didn't come.
No.
He has come. Let us see the accused, what accused says. Because the accused right is involved. You have not implemented accused.
In 311 petition, my lord, I have not.
Accused right is also there. They have a say.
Yes, ma'am.
Particularly PP is not coming. You are coming forward.
Yes.
Implead the accused. Mr. Tripathi seek leave of the court to implead the accused person in the present case as the opposite. How many accused are there?
My lord, 4.
4. Issue notice to the newly implemented opposite party. The petitioner is the informant in the present case, and he is agreed by the order dated 30/7/2024 passed by learned
Assistant Sessions
Sessions
from CGM Ganjam.
Yeah, in session number 25 of 2022, whereby the application moved by the prosecutor under section 311 CRPC for re-examining 4 witnesses, have been turned down by the High Court. Okay.
But I have to amend the
No, you
Consolidated.
and file the
consolidated cost title and also take notice.
Yes, yes.
Right.
25. The compromise in the meantime, compromise has made, my lord.
What are the offenses?
Offenses, my lord. Already they have got married.
376 and 294, 506. Petitioner is a lecturer, Your Lordship. I mean, this cause.
They have already got married.
Judgment, Your Lordship, is squarely covered by Your Lordship. That.
Lordship issue notice, they both will appear before.
What is the stage? Stage of
Stage,
Only FRAG.
FRAG auction the protection.
Interim protection by part by
That
coordinate.
has not been filed.
No.
And where is the proof of marriage?
Marriage,
Except FIR, you have not filed anything.
Coordinate bench in the ABLP applications 2469 2024 has granted interim protection to the present petitioner for the purpose of marriage to the victim.
Where is that? That order is also not there.
But my Lawrence Senior not filed, but that is in 2469 2024 in ABLP application.
At least you placed these things on record. Have you said that you have married?
Yes, yes.
Where have you said? In the petition, where have you said?
Lecture.
Paragraph
Marriage question.
paragraph 4, Your Lordship, page 3.
3 re. In the meantime, the matter is amicably
got married.
settled. Yes, ma'am.
Hey, na the whether interim protection jason.
What is the age of
Age of the girl is 22 years.
petitioner is seeking quashing? Petitioners are seeking quashing for the FIR number so.
20 years.
Registered at the instance of opposite party number 2 for alleged commission of offense under section 4. When is that anticipatory bail?
ABLP 2469 of 2024 5 Your Lordship.
Give in writing. Petitioners approached this court. Petitioner number 1 or all the petitioners?
No, other petitioner are
Different
granted. They are on the
Talking about petitioner number 1 or what?
This is
Yes,
Your Lordship,
yes.
just now.
Petitioner number 1 approached this court by filing ABPL number
2469 of 2025 Your Lordship.
25.
Other were
This
granted
court-
anticipated.
This court by the order dated enlarge the petition number 1. They extended the concession of interim 3RS bail on the ground that the petitioner would marry the opposite party number 2. Subsequent thereto, the petitioner has married with ordinary Bharati legal activity. Subsequent thereto, the petitioner has married the petitioner number 1 married to the opposite party number 2. On marriage date is also not there.
They have also applied for registration marriage.
When have they married?
They
There is compulsory interim bail is I think in marriage age in I know.
Very poor way of drafting marriage date also you don't know. Nothing is known.
1st March to
Where is that? Where will I
2025,
get?
my lord. This is the application they have applied for marriage.
In the petition, where will I go get?
See the date of लिखी है. They have applied on 1st March 2025.
Notice to opposite party.
Yes.
Proper issue notice to opposite party. At least these things you should
Fix a date, they will appear, my lord.
Fix a date. 7th, 8th. Yes. Next.
26.
Kind approval. But that 125 proceeding is not in execution. That has been disposed of since 2016.
Obviously,
Now,
obviously the order is made that has become final. You have not challenged. Obviously, therefore the execution.
Yes. Now
What is the big deal?
in the execution proceedings, NBWs are pending.
Obviously,
That
this is
is
obvious.
So
I ज्ञान लगाएर कौन होती?
let me
125 order है you have not challenged. That I didn't file anything. He is filing execution.
Yes. Now,
As simple as that.
now, no, the
You have challenged that order.
no. That order has.
That's your problem. I'm not sitting in an advisory jurisdiction here. I'll not keep on advising you. What to do, you know that.
Because that was under challenge. The revision petition was.
I don't know. You know what to do.
Yeah. Just
there is an order of maintenance.
Yes.
That order is attained finality.
Yes.
And thereafter the execution petition is filed.
Yes.
I can't quash the execution without quashing that order. If that order stands, then execution has to go on. As simple as that.
Only I confined into like.
How can I quash an execution proceeding if the main order stands?
For the present, I only confined to the order of NBW.
Then I'll have to dismiss that. That's not maintainable.
Order of NBW. Let them appear.
Only NBW. Then appear and resort to the remedy. I'll dispose it up. I'll dispose it up.
No. What I beg to say.
Why don't you answer this small thing? You have argued 20 minutes you have wasted. If there is an order, principal order,
yes,
which is sought for execution, the principal order stands, then execution continues.
Yes.
How can I quash the execution if the main order stands?
Not.
I
have sought for.
Shall I waste another half an hour to make you understand this?
I have only sought for the quashing of.
I have given you option that you challenge that order.
Only
if the main order set aside, so that the execution I can interfere. What can I do if that order stands? It has to be executed. It has to be executed. Execution case cannot be quashed like this.
I don't pay. I don't press this for quashing of execution. I only press for NBW's issue.
Which item you are talking about?
17.
Huh? 17. I reached 26 now. I'm going 17.
Only I confine.
Maintain little decorum of this court. Why are you doing all this thing? I don't understand. I'm giving indulgence doesn't mean that you can deteriorate the standard of this court to this level. I'm in 26 item. Suddenly you said you thought something and stood up. You argued 20 minutes. I made you understand what to do, what not to do. Don't do that. It will affect the other cases. Tell me the NBW. When NBW?
NBW dated.
Dispose it up, saying that go and appear. Okay. Right on.
NBW dated 29/7/24. See, somebody else has taken. He might have typed it out. All this confusion. Right on. Petitioner is seeking quashing up for the execution proceeding. Number CRP bracket execution EX number 156 of 2024. Arising out of what is the principal order? Arising out of maintenance order passed by CRP number 155/2014.
Arising out of criminal proceeding number 155 of 2014, whereby the family judge Jajpur had passed an order for maintenance under section 125 of CRPC. The Land Council for the petition submits that the maintenance order has attained finality. Hence, thereafter the execution petition has been filed. Since the maintenance order has attained finality, and the execution petition cannot be quashed unless the principal order directing the petitioner to pay maintenance is varied by the competent court. Be that as it may, Land Council for the petitioner submits that by the order dated 18/5/2022, the execution court has issued the NBW against him.
In two proceedings. One 18/5/22 in execution proceeding 39 of 21 and order dated 29/7/24 in execution case number 138/23. And 29/7/24 in execution case number 138/23. NBW
156 of 2024 and 138 of 2023. On instruction, he submits that his client would be appearing before the court on or before the 30th of April and resorts to the remedy under law. Subject to petitioner appearing before the court, the execution of NPW issued on certain date by the family judge Food, son, remain stay, remain stay, remain stay. With this observation, the petition is disposed. Yes.
I look like.
Yes.
Sorry, extremely sorry.
26, it's all right. It's all right. 26.
My lord, that is the offense under. It is civil dispute. Civil dispute. Lordship issue notice. There is some money transaction, my lord.
Okay, I'll issue notice. Money transaction. Is it money transaction?
Yes, your lordship, but 406 and 420 is there.
It's all right. If they settle, why not?
No.
Issue notice, huh? Yes.
27.
Item 27, I am permitted through BC. Am I audible, my lords?
Yes, yes.
My lords, quashing of the proceeding under Annexure 2 on the ground that relating to the same incident between same parties for the same offences, my lords, 2 affairs lodged on the same day. First one is at Annexure 1, page 9, is by the husband, and the second affair, Annexure 2, page 13, is by the wife, my lords. And the offences in both cases are same, my lords. And it is a case of double jeopardy, my lords.
What are the allegations?
Allegations, my lords, allegations, Annexure 1, the offences 126, subsection 2, 115, subsection 2, 355, 296, 351.3, and 3.5.
Tell me the allegations, don't say the sections.
Yes.
Allegation says, I am placing, my lords. Allegation is that on 10/1/2025 at about 9:30 p.m., one Manmohan Sahu and his associate Ramanand Das entered the Lima 4 campus house and abused in obscene languages and assaulted him, for which he sustained injuries on his person, my lords. On this report, ISC Cantonment PS case number 11 of 2025 under such and such offences were registered. And now, my lords, lordship, kindly see the second affair, my lords. The allegations, my lords, are same, my lords.
Who is the informant in the second affair?
Second affair is the wife. First and second wife.
Husband. His husband.
It's
all right, I understood.
Here is the case. The present petition is working is a ASA communication lordship in Lima 2462 as a operator. The present petitioner is the Manmohan Sahu is a OIC, regularly harassing the present petitioner lordship. That effect by regularly taking alcohol in the office of the present petitioner lordship and abused in filthy languages, and by taking his wife, used blank language in favor of his wife. Therefore, first husband is lost the affair, that is Annexure 11, Annexure page 11, Annexure 1. Thereafter, the wife of the present informant again lost the affair against the present petitioner lordship by alleging so many allegations while he entered into the
same day both the affairs.
Same incident and
allegation is different. There is a same. Though the occurrences take place in 10/11/2024, your lordship, but the allegation is different. Assault kale jete phone kale informant first case informant phone kala wife ku gala par slang.
Why the 2 affairs?
First affair is lost by the
incident is same.
Yes, that is right.
The long and short of the matter is the wife and husband are being harassed by this petitioner.
Yes, regular.
After drinking, whatever.
Yes.
An incident has taken place a particular day, and the same day 2 FIR. Wife registers 1 FIR, husband FIR.
That is there. That is first affair.
Why? 2 FIR. Both the FIR should be clapped together and.
Yes, but quashing up on due to second affair.
Yes, sir.
My lord, second affair is not
which FIR you are now?
Second affair, Annexure 2, my lords. Annexure 2.
2.
My lord. Second affair, Annexure 2. That is Cantonment PS case number 13.
Since the incident is arising out of the same this thing, and let the police investigate both the FIR together.
Millards, police is
Showing
investing,
up.
but notice may be issued, Millards, because this second
Whom
FIR
should I,
should not stand.
whom should I issue notice? I'll issue notice to whom?
Millards, law protects me under Article 20 subsection
No,
2,
you
Millards.
don't
No
go
double
to Article 20. You tell me first, whom should I issue notice?
Millards,
See your
informal
cost title. See your cost title.
informant is if it is appropriate, Millards.
Where is the informant? You have not implemented.
Millards, I will implement, Millards.
You implement and come.
Yes.
You implement and come.
Millards, notice may be issued, I will file the consolidated cost.
After you implement, come, because the investigation is going on. Implement, come. This is complete, incomplete petition. After 2 weeks, yes. Next. Simply after 2 weeks, yes.
28.
Nothing.
May I please, Your Lordship? My lord, here the application is for quashing of the cognizance order dated 12/12/2023. So, here the complainant is the daughter-in-law, my lord, and the allegation is against the father-in-law and elder brother-in-law. So, dispute arises out of the distribution of the property. So now the informant is also repenting. They are living on the same roof. So notice may kindly be issued.
Now, what are the offenses?
498, 376, 354,
Where
354B.
from I'll get it? You have not filed anything. In the name of annexure, you have filed only 1-page order. No FIR, no, nothing is filed.
FIR is just
1-page order by which the cognizance is taken. Let us see the FIR at least.
I am
376. It is what not? 354, A, B, C, D, 323, 506, 34, 376, everything is there.
Yes, my lord.
At least file the FIR, file the charge sheet. Something you have to file, not half a page order and quashing.
I am appearing on behalf of Mr. Panda. So
maybe, but where have you said that you have settled the dispute? Nothing is there.
Notice may kindly be issued.
No, I will not issue. This is a frivolous petition, according to me. Complete frivolous petition. Absolute frivolous.
Next week. I'll file up that document.
Nothing is filed, only 2-page petition and cognizance order. Quashing. With 500 cost, additional document. Pay to the boss 500 cost. File additional document. Yes.
29.
May I please, ma'am?
In this petition, except the order of cognizance, no other document is filed. The petitioner is seeking quashing up for the entire Finland procedure. Check this stage, the petitioner is seeking time for filing additional document to substantive stage, letting people with the English, subject to paying cost of 500 to the bar. Yes.
Cognizance order तले से FIR टा देइछन्ती might have in cognizance तले से order FIR copy टा
Where is that item?
page 10 11 अछि page 10 11 12 13 अछि
अछि
but my index not have mentioned
28 na
item
that is 28 28 madam.
Where is that?
Page kind
Page 11.
Page 10 11 is the FIR order, sir. 10 11 and 12 13 is the recital of the FIR. But in index, my learning friend might have not shown as the FIR, but only cognizance has been shown.
Even the charge sheet is not filed.
Charge sheet is not filed. Therefore, Lordship, but here is allegation very serious in nature.
Yes.
Allegation very
only
serious.
Except FIR and cognizance of charge sheet is not filed. File the charge sheet.
Yes.
After 3 weeks. Yes.
Here a complaint case. Madam, turn to page 9.
9.
Because the allegation starts from page 9. Clause 8, विवरणी 25/6/2013 तारिख 2 नंबर मुदला पिटिशनर 1 नंबर मुदला को धरी मुदे बासस्थान ठाकुर मुंडा 10 चकिया टाटा ट्रक खरीद संबंध जोगाजोग कले जार नंबर सचेंसर एवं जेहेतु सी राम फाइनेंस ऋण परिशोध बाकी थिला उभय मुदे मुदला द्वारा स्थिर हैला 1 नंबर मुदला नॉट द पिटिशनर मुदे को 1,10,000 टंका प्रदान कले एवं अवशिष्ट रूप ऋण टंका फाइनेंस कंपनी परिशोध करिवे उक्त संबंध में मुदेई 1 नंबर नॉट द पिटिशनर मध्य आनंदपुर कोर्ट रे नोटरी पब्लिक दयानी दास को निकट रे 25 तारिख रे चुक्तिनामा संपादन हैला এবং শ্ରୀ ହେମନ୍ତ କୁମାର ପତି ଓକିଲଙ୍କ ଜରିଆରେ ପଞ୍ଜୀକୃତ ହେଲା ଏଥିରେ ସଚେତନ ଷ୍ଟାମ୍ପ ପେପର ବ୍ୟବହାର ହେଲା ଏବଂ ସମସ୍ତ ସାକ୍ଷୀମାନଙ୍କ ଉପସ୍ଥିତିରେ ଉକ୍ତ ଚୁକ୍ତିନାମା ସମ୍ପାଦନ ପରେ ଗାଡ଼ିର ଅରିଜିନାଲ ଡକ୍ୟୁମେଣ୍ଟ ସହ ଗାଡ଼ିଟି 1 ନମ୍ବର 2 ନମ୍ବରକୁ ମୁଦ୍ରା ଦିଆଗଲା ହଠାତ୍ 14/2/2024 ଦିନ ଶ୍ରୀରାମ ଫାଇନାନ୍ସ ଓକିଲଙ୍କ ନୋଟିସ ପାଇଲା ପରେ ମୁଦେଇ 2 ନମ୍ବରକୁ ମଧ୍ୟରେ ଯୋଗାଯୋଗ କରିବା ପରେ ସେ ଧରାଛୁଆଁ ଦେଲେ ନାହିଁ କି ସହଯୋଗ କଲେ ନାହିଁ ତତ୍ପରଠାରୁ 1 ନମ୍ବର ମୁଦାଲାଙ୍କ ଦ୍ୱାରା ଦିଆଯାଇଥିବା ଭୋଟ ପରିଚୟ ପତ୍ର ଠିକଣା ଅନୁସନ୍ଧାନ କଲା ତାଙ୍କର କୌଣସି ଯୋଗାଯୋଗ ନ ହୋଇପାରୁ ଠକେଇରେ ଶିକାର ହେବାର ନିଶ୍ଚିନ୍ତ ହେବାରୁ ଉକ୍ତ ନ୍ୟାୟାଳୟ ପ୍ରୟାସ କଲା My humble submission, so far allegation of this agreement, execution of agreement, payment part is concerned, that is against the other co-accused, not against the petitioner matter. Only part what is my role to the extent, but at best it may be an offense under section 109 to that, but there is no cognizance under that matter. And so far the other aspect is concerned, it's through agreement things has been materialized, and it is also admitted the case of the complainant that a agreement was executed and there was some understanding between the parties for repayment of the loan, and it was not materialized. So at best it's civil liability, madam. And
show me the charge sheet. What has come after investigation?
I can cognizance copy the madam. Turn to page 15.
15.
Again.
15.
Complaint case, sir.
Yes.
Madam, I see 406, 420. Insert.
No, cognizance is all right, but I need to see what are the
I'll charge it with complaint case.
Complaint case. What are the statements? Sorry, statement.
No. Statement I'm going to appeal. We have not yet entered appearance.
Then how will I know whether the
this
made out or not?
With all listed matter,
you, by the way, what is your name? Your name?
My name is Santosh Kumar Sahu.
1 lakh something. The disputed amount is
1 lakh.
1 lakh.
Against the other co-accused. Yeah, against the kitchen.
Chalo, I'll issue notice. Let him come. 1 lakh. Why don't you pay 3 of you? 3 of you. You are friend.
Yes.
You all of you are together. Don't make out that.
Because of some some acquaintance.
You might have shared the booty.
Booty could have seen here.
Fraud करेंगे नहीं चलते मिशी की शादी.
Fraud ही नहीं. सीधा गाड़ी पे गया. सीधा गाड़ी पे गया. गाड़ी रो जो.
Whatever you principal accused according to you is also your friend.
सीधा सी allegation कौन सी? I'm not admitting.
And issue notice let us settle it because I.
ठीक है.
It's very minor.
And recent case में miss case is there, say for the posting.
Oh, application, na? Application. We'll move application for adjournment.
Please stay.
No. Because other accused persons are there.
467.
I will not say because other accused persons are there. You move application and she can adjourn according to you. And that benefit will be anyhow to the principal accused also.
Obvious. Let him come and
let him after 2 weeks roko and the process immediately. We'll settle it out. I'll just come on.
That husband wife related to sale of land.
That police has to serve the notice to the informant. They have not taken step. He has asked for 1 week time.
See, I purposefully kept it because he was insisting for stay or some interim order.
I was shocked because in the petition I have stated I was forced to pay 5 lakhs and civil right and for civil all that I'm not going.
I have recorded those things.
Yes. Yesterday again that in spite of this notice copies were sent and he has the audacity to threaten my son. You come with money. At least my learned friend may instruct him not to do it.
Just
or
see what is this going on. It is a civil dispute. He is ready and willing to execute the sale deed, give the money. He is not, this is completely pure and pure
And also-
simple, civil case. Pure and pure. civil case.
Yes. Not responding to my
If that's the problem, let him file a specific performance suit. What is this? Tell the IO, you call up and tell the IO that I am giving you 1 week time. I'll put it on second. No, third of this month. But make sure that you telephonically give message that you serve the opposite side and don't create all this problem. Otherwise, he has to come and appear. The IO is a collecting agent or what? He's calling him and making him sit and 5 lakhs as it is, he has extracted. This is the real thing these police people are, they will never do. They become a collecting agent now. What is this going on? I am giving a lease it on third on the request of Mr. Vishwal to lease it and make sure that you call him and tell.
Yes. Let him also communicate the opinion and lordship express so that at
Yes,
least
that's what that is
not
the
to
reason
harass
I am
us.
expressing this. He will do it, I think. He'll do it. And please remind him so that he can in the evening he can call. Yes.
Yes. I checked up in the morning itself. He is not responding to their message.
Nikuda is waiting. Record RTK पर करेगा 140 145 करेगा. Note show करेगा 140. Yes, 30. Yes.
Therefore, quash the proceeding, my lord. Offense under section 498A. Why is my lord?
I'll issue notice. I'll issue notice. 498. Okay. Yeah.
Permitted to impede informant as a party, my lord. In the hard court, my lord.
See, these are matrimonial disputes. Why are you not making? Wife is not party. With whom you will settle?
Sorry, my lord.
Third count for the petitioner seeks leave of this court to implead the informant. As the opposite party to let him do so by tomorrow. By tomorrow, issue notice to newly implemented opposite party.
Take the proceeding, my lord.
First of all, incomplete petition. I will not do it. I would have done it. If you do bona fide, I'll do it. Otherwise, nothing is going to happen.
Proceed ହେଇଗଲା compromise ରେ କିଛି ଲାଭ ହବନି. Going to compromise.
ଆପଣ କୋଉଠି ଲେଖିଛନ୍ତି କହୁନାହାନ୍ତି? କୋଉ stage ରେ ଅଛନ୍ତି?
My lord.
In the petition, wherever you state that, what is the stage?
That is IN number 908 of 25.
No. What is the stage?
Stage only deposition ପାଇଁ notice ହେଇଛି Saki.
Deposition of what?
Deposition of informant, my lord.
Wherever you said that nothing is there on record, except FIR.
The ST case number, I am mentioning the ST case number.
Wherever you said that, what is the stage of the proceeding?
Stage is only notice.
You don't write anything, except FIR, you don't file anything. You don't implead the informant. You want a stay. Don't do disservice to the court also.
Proceed କରିଗଲା compromise going to be compromise.
No, I will not do it.
Compromise.
Because of the kind of petition you have filed.
Lordship, compromise.
You see what are the annexure you filed. Wherever you say that you have settled the dispute, you have not included the informant. You don't know what is the where is the stage of the proceeding. I'll stay it. How can I stay it like this? Without knowing anything?
Notice ଯାଇଛି ସେ informant exam.
I am issuing notice. Therefore, I am issuing notice.
Lordship, proceed କରିଗଲା compromise ହେଇପାରିବନି ପୁଣି ଯୋଉ କଥା ସେଇ କଥା ହେଇଯିବ.
Then withdraw it. File. Let it comes for the petition seeks to withdraw the present petition to file a better petition with better particular and relevant documents. And impleading the opposite party, impleading the informant as an opposite party. Leave is granted. Let him do so within a week.
No, withdraw କରିବ. Lordship, withdraw.
I don't understand what kind of submission you are making.
No, next week you would date though in the meantime.
That's what I am doing, sir. I am issuing notice and implead the informant. It is a 498 case. The informant is a necessary party because you are settling the dispute, and I am issuing notice. And you don't know what is the stage up for the trial, and you don't know anything. You have not written anything.
Examine notice it is my
Where will I get those things? Where will I go to get this thing? Have a stay order.
एसटी केस ହେଲା ପରେ ମୁଁ ଫାଇଲ କଲି ଇନ ଦି ମିନ ଟାଇମ 1.5 ମାସ ହେଇଗଲାଣି 1.5 ମାସ ଭିତରେ ନୋଟିସ ଯାଇ
Except FIR, you have not filed anything in this petition.
दिस इज माय इंस्ट्रक्शन मैडम
Instruction I on the basis.
नेक्स्ट your lordship posted it next
Don't
week
waste further time. I'll dismiss it with cost. I'll tell you. Don't cross the limit.
notice ଟା ହେଲେ
There is some limit. I am giving indulgence. Doesn't mean that you will keep on saying.
compromise ର
Let it be like that.
both
Why have you filed like petition like this? Yes. 32. Simply at the yes. 30.
In fact, earlier approach your lordship. That
Right, sir.
Yes.
Right, the petitioner has appeared.
well, page 94, your lordship may kindly, in fact, consider.
What are you seeking here?
Well, considering the health condition, your lordship granted liberty me to approach the London court below for interim bail. Now the interim
You
bail.
got the interim bail.
Pardon my.
You got the interim bail.
No. Now he has rejected as if it is a bail petition. Your lordship has referred, in fact, the word you used, your lordship, is that terminal ill. And I have filed, on 16th he has undergone
Now
bypass.
what are you seeking in this petition?
This 2 months interim protection, at least 16 tarikh operation se heichi. I have brought on record that that is at
So what are you challenging? Let me.
the rejection of the interim order, interim bail application.
Where is that order?
That order is at
Starts from 110.
Because in your prayer you are not saying
Page
anything.
130.
yes.
All Article 21 dialogues. What are you challenging?
This rejection of the interim bail
And
application.
you have given all dialogues of Article 21, 122. In the
Associates,
prayer you say that I am agreed
now-
to this order and set aside.
nowadays,
Except that you have said everything.
now the associates have started writing
No,
lengthy.
the fantastic English and all without having anything.
Amadu semane better.
In the prayer, Jesse, what are you asking? I am not able to understand. You are agreed by which order then? Right.
Page 110, my lord.
Annexure
10.
10.
Annexure 10. It is very exhaustive petition, but main thing is missing. Anyway, this your application is rejected.
Rejected. The 111, the London Court below has taken note of the paragraphs from your lordship's
Case
order.
of 20B of the NDPS.
Yes. Thereafter, he has
Applied
hard
for the
and
bail.
applied mind as if it is a bail application. And instead, terminal ill, the word used, and moreover, of course, I don't say that the court can do like this, but just for a moment, if 101 page be seen, what is his health condition? Sorry,
You are supposed to surrender by 1st July 2024.
my lord.
And you got extension thereafter.
But thereafter, I have approached your lordship. Your lordship has directed within this period you approach. And I have approached. But the court said no, since it is a 20B case and other things. And I have, even though page 101, he has undergone bypass, artery bypass grafting. And not only that, his discharge certificate says that he was admitted as a kidney patient. Dialysis daily, 109.
The interim bail application is rejected.
Yes, Lord.
Yes, Mr.
Why not? Earlier, previously, he had approached before this.
See the condition, health condition.
Yes, I have seen.
See the health condition. What will you do keeping these kind of people in the jail? There is something called humanity also. You can't, and what to do now? Shall I set aside and send it back for reconsideration? What will I do?
Your lordship,
It's a 482 petition.
Your lordship, this prayer is protecting. 2 months may at least they can for the time.
Let me take instruction from the concerned police. Present health condition. Thereafter,
Yes, file the medical document. Just see
Yesterday
what police will say.
And the court has also noted that the person has been produced before the court in an
Where is the
ambulance.
where is the medical document you filed?
Page 101.
101. 101. Okay, 101. I don't know. Issue notice to the state, mutual accept notice. Mr. The state council to seek instruction regarding the health condition of the petitioner and verify the documents page 100. Page 100 of this petition, 100 of page 100 of the petition, release the matter on second. I will allow it. Only ex parte I don't want to allow, therefore I am giving. I'll allow it.
And there at Raipur, if the family member will document or police has to go that far, that is what.
Somehow you do it by phone or whatever. This is only formality.
Only survive for the noble scheme of insurance of the state.
You will die unnecessarily.
Shall
I put it on second, third? Third would be better. Huh? One working day at least will be better.
State has already spent 6 lakh.
Tell him to orally get instruction from, because he can't go to Raipur and get and all, you know.
33, I pray for adjournment.
Okay, adjourn. Yes.
34.
Yes, madam.
Petitioner prays for questioning the entire proceeding, but there is alleging that between petitioner and informant there is assault. So notice me issue. The informant.
Have you settled the dispute?
Yes, sir.
Huh? Where have you said that you settled?
He has not stated any.
Not stated, but there.
You in the petition have you settled? Have you stated that you have settled the dispute?
No, Lordship.
Unless you have settled the dispute, why should the court will interfere?
Yes, sir. Paragraph 7.
7. Have you said that? Okay, let us see. 7, huh?
Yes, Lordship.
In the meantime, at the.
Yes,
They decided to compromise the matter outside.
Minor offenses.
Yes, Lordship.
Issue notice, huh? Opposite part. Next.
35.
Lordship, I am for the petitioner.
The petitioner submits that the parties have going there into the settling and to Quashing to entire criminal prosecution in the premise. Yes.
Lordship, I am for the petitioner.
Yes.
Lordship, I am challenging order 24 December 2024 passed in a criminal division. Lordship, this matter is a counterblast. The mother of the present petitioner had filed an FIR against the present informant. After that, the informant has filed an FIR against his son. His son is working in is a government servant working in Orissa Fire Service. He was not present at that point of time. The charge sheet name doesn't reflect in the charge sheet. Neither the cognizance has been taken, nor during the frame of the charges his name was reflected. And after that, they have invoked 301-2 by the present informant to implicate him as a accused. All the witnesses have been examined and no material is available. There's sufficient material available.
Examined means before
Learned court.
Yes.
The sufficient material is available.
Where are the deposition?
Deposition.
He has challenged the 319 application has been filed by the.
Let us see the deposition. You have been summoned under section 319.
319.
Yes.
Where are the deposition? Let us see what are the evidence came against you.
Deposition.
How will I decide 319 is properly applied or not? Unless I see the deposition. What are the evidences against you on the basis of which you have been summoned now?
That is there with me, but Lordship is not in file.
Then keep it with you. Keep it with you. You are challenging an order by the which 319 is invoked and summoned to you. You will not file the deposition. How will I know? These are the documents, minimum documents. 500 you pay and file it. Bar. Because minimum document, if you don't file 500, pay 500, additional document to be filed, 500 pay 2 bar. I will lease it immediately after 1 week. Okay.
Ali, a stay maybe.
What are you talking?
Name doesn't reflect in any of the trial court.
Because you are saying, where is the evidence? Without seeing, you say that.
Charge sheet, my lordship may have an annex.
Forget about the charge sheet. Now it is 319. You have to see the evidence. Simply then 1 week for 1 week. 1 week. File those depositions and pay 500 to the bar. 1 week.
Obliged.
Immediately file it. Otherwise, it will not be listed after 1 week.
May I
You will be in trouble.
challenging the criminal proceeding, my lord, on the ground of compromise, my lord. Offense under section 306 of IPC, my lord. Allegation is that, my lord, the deceased, he has taken money from the petitioner for 40,000, my lord. Thereafter, he returned 32,000 and the rest of 8,000 was with the deceased, my lord. He has not paid that. For that reason, my lord, the petitioner time and again demanded the money. After that, my lord, he committed suicide. That is the allegation.
There is one judgment, recent judgment I have.
Yes, madam.
Where is that?
That judgment I have quoted that, madam.
Where is that?
Paragraph 8.
Para?
Para 8.
8, huh?
Gyan
Oh, yes.
8?
Paragraph 8 here.
No, not Gyan Singh. My judgment.
My lord.
One of the judgment I passed, saying that recovery, because of the recovery, if somebody commits suicide, that is.
That can be, my lord.
Where is that judgment? I pass it over, get it.
Your lordship may issue notice to the opposite.
You get that at least.
Obliged, my lord.
Don't make shortcut. I'm
My
passing it over, get that judgment. I'll do it, but get that judgment.
Obliged.
Mr. Milan can go appear in that.
Man, after lunch. Okay.
Yes.
Here the under section 450 and 392-34 amicably settled. The matter has been amicably settled.
Settled.
It was the dispute between the mother and son.
I'll issue notice, mother sons. Issue notice. Yes. 38.
Please, your lordship.
How many matters? 1,
5.
1, 2, 3.
My lords, the
Five.
petitioner before your lordship.
5 matters. You are appearing in the all the 5.
Petitioner before your lordship, my lords. She was posted at Sambalpur Development Agency, my lords, as the.
How 5 cases? Because she is same petitioner.
Yes, same petition. I am submitting what has happened. Now it came to her notice, my lords, that a racket was going on there and her signatures were being used forced and forced plans were being given. So she lodged 2 FIRs, my lord. I have annexed those FIRs as annexures 3 and 3/1, my lord. Page 30, my lords.
Yes.
These affairs were lodged by me in the month of August, my lords.
18th August.
My lords.
Yes.
And they are still, my lords, under investigation. It appears.
This FIR against whom?
The affairs were lodged against, first, page 31, against one Harikesh Bahadur Singh, the person to whom I allege that I have not put my signature nor issued the plan in favor of the applicant Harikesh Bahadur Singh and the other person, my lords. So, in course of investigation, my lords, one person from the planning department was apprehended, my lords. Then when this fact came to light, my lords, other people, my lords, also lodged affairs, my lords, saying that the plan which they had received was a duplicate plan. And this man, my lords, the planning department man who was taken into custody in these cases, he was taken into custody in these affairs. So he stated, my lords, that it was done in connivance with me, my lords. So therefore, I was taken into custody in one case. The IO says that he offered me section 41. I allegedly refused to accept 41.
Taken into custody.
So for 4 months, I had to remain in custody in about 11 affairs, my lords.
And these 5 FIRs, my lords, now charge sheet has been filed against me without, my lords, any investigation having been done into the veracity of the documents as to whether those signatures are mine or not. And the allegation, charge sheet has been filed saying that 60 days is going to be over, hence submitting preliminary charge sheet.
Keeping it open, 173.
Yes.
Open.
And thereafter cognizance has been taken.
So what are you challenging then?
Well, I am challenging the cognizance, my lords, because in the first case, your lordship may see. First case,
let us see the charge sheet. In the
page 9, my lords may see the order, my lords.
Page 9.
Yes.
Yes.
Here, my lords, charge sheet has been filed, 4th line, under 420, 120B, read with 34 IPC, against accused Vikas Jagat, Bulu alias Lakshminarayan Samal, and Bandita Mahapatra. And the court takes cognizance, my lords. Now, your lordship may kindly look at page 13, that is the FIR.
1313. Okay. Yes. Yes.
The FIR is by the person concerned to whom that plan was given, one Dr. Pradipta Kumar Panda. He writes at page 13, allegation against Mr. Lakshminarayan Samal, dealing assistant SDA Sambalpur, and engineer Mr. Vikas Jagat of Sambalpur for taking 5,50,000 by a self-check dated 5/3/2023 for requisite fee for commercial building plan sanction and not depositing the same in SDA office account of Sambalpur. He has said, on 4th August afternoon of 2023, I along with Sasikanta Sahu went to SDA office, met Mr. Lakshminarayan Samal, dealing assistant of SDA, in his office room to discuss about sanction of my building plan and fee structure to be deposited with recommendation of engineer Vikas.
In the entire complaint, your name doesn't.
No.
You are appear to be the conspirator subsequently. Yes, Mr.
Charge sheet
open.
Charge sheet page
31, page 31. Yes, 28.
I received in middle portion, the check number so and so. I received information from Sanjay Kumar Naik, IIC Ointapalli, that accused person Bandita Mahapatra, in a present petitioner.
Yes.
Bandita Mahapatra, so and so is the planning member, district Sambalpur, was arrested in so and forwarded Honorable SDGM court in connection with the Ointapalli police case number 369 under section 420, 468, 471, and 34 IPC, who is also involved in this case.
What are the material? That's what he says. That he says that except the co-accused statement, there is nothing. Because in the complaint, his name was not there.
Complaint was not there, but
nothing was there.
Investigation, they found that
you were taken into custody in some other matter.
And some other, in this case also,
what are the materials? That's what I'm saying.
Therefore,
in cases, except the statement of the co-accused person, there is nothing.
Thereafter,
you find out and tell me the materials. I will issue notice. Find out. If she was nowhere in the picture.
Yes, ma'am. But during investigation, his name is found that that person is.
Let us read the 161 statement and all, where his name figures. How she comes into. Just I am issuing notice in all the 5 months. Issue notice all the 5 months. Yes.
Lords, may I pray along with notice, let further proceedings be stayed. I have now retired, my lords.
No, the problem would be once I stay, the other co-accused persons will also get benefit of it.
Who?
Other co-accused persons?
Everybody is now on bail, my lords.
No, bail, proceeding, you move, insofar as you are concerned, you move application and let you move an application for it.
Your lordship may say that.
Application. But the full trial cannot be stayed because other accused persons are there.
On my moving an application also the same thing will happen.
No, you may move application 317.
317 is not required.
Through counsel you keep on.
What I am submitting is this, my lords. This is a case, my lords, where
It's under the aid of 120B, you have been roped in.
yes,
Looks like.
yes.
And what are the material? Nothing is
No,
coming.
that is there in the charge sheet itself, my lords, which my learned friend placed. I am placing it.
Let us see 161 statement of other witness.
My lords, I am placing what what has been stated in the charge sheet, page 28. He says that he got information from the IIC Hon'Ble PS that
I know that I read it.
Yes.
That I read it. There is
That
no
is the
material.
only thing. What
That's the
he has
reason I am
done
taking
is,
notice.
he
That's the
has,
reason.
he has seized my forwarding report. What he says is this. I seized one Xerox attested copy of forwarding letter, one Xerox attested copy of arrest memo, 3 Xerox attested copies of FIR. All copies are in connection with Hon'Ble PS case 369 of 2023 on production by Sanjay Naik, IIC Hon'Ble PS. IO of the Hon'Ble PS case number such and such in presence of witnesses prepared
I understand that that's
as
there is
prima
nothing
facie evidence
except-
under 421.
Except the arrest memo and all in that Hon'Ble case, there is nothing else.
Yes.
Issue notice and let it move application. Yes. Huh? On separate order. kar do.
These are all separate cases, so they should not be tagged together. They should
Separate.
come separate.
Yes.
39 and pass over.
Pass over.
40. May please.
Lord, in this case, I am challenging the cognizance, my lord. Annexure 3, page 37, my lord. The basis of the
37? Page
Yes, ma'am.
37. Yes.
The offense under section 498A 320.
Matrimonial dispute.
Already, my lord,
Compromise is-
annexure 5 to compromise already. Both the party
Issue notice.
divorced.
Issue notice. The written will also. Then comes for the petition submit that the dispute is arising out of a matrimonial discord and the parties have settled the dispute. Issue notice to opposite party number 2, written will also, which is installed as notice by the state. In the meantime, proceeding before so and so is stayed. Okay.
I have filed I have.
I've already stayed the proceeding.
41.
My lord, my senior is an accommodation, kindly adjourn the matter.
Okay, adjourn. Yes. 42.
43.
ये 302 case here.
Simply
Congar
not.
court कर दी तर
Non appears for the petitioner in the interest of justice adjourned to after 4 weeks. Yes.
44.
Nothing in that appears. 44. What?
Matrimonial matter, my lord.
Matrimonial
CPA allowed.
44?
Yes, my lords, in this case, the
Issue notice.
matrimonial, yes, when divorce has been granted, my lords.
Divorce.
Yes.
Okay. Divorce, they are settled now.
Not settled, my lords, but the proceedings are unduly prolonging. My lords, what has happened is two applications for divorces have been filed, and ex parte decree of divorce has been granted at the instance of both the parties, and it has not been challenged before any forum of law. My lords.
Petitioner, petition is seeking quashing of the petitioners or
Petitioners, my lords. Petitioner number 1 is the husband, and
proceeding arising out of FIR number so. Then comes for the petitioner submits that the marriage between the petitioner number 1 and opposite party number 2 has already been dissolved by
Yes.
ex party order, which is attended final.
Yes.
Issue notice to opposite party.
Great.
Yes.
45.
May I please, Your Lordship. My lord, the informant and the petitioner 3 are the director of the Hon'Ble Hospital. Entire transaction made in the affair are already agitated in the civil suit. And the status order has been passed.
You are the director of?
Yes. Yeah.
What?
And the Hon'Ble Hospital, in between the compromise.
6 crore has been cheated.
There is compromise between the parties. All of them have taken
Let
the
us
money.
understand who
There, petition number 1, yes. He is a managing director of the Swiss holding company.
Holding company?
Yes.
Yes.
And number 2, he is also director of that company. Number 3 is the director of the Hon'Ble Hospital. Number 4 is a chartered.
What are the allegations?
Allegation against my lord that, but you also kindly state in the FIR manner that he has given the land to the opposite party number 2.
Land and
Number one.
building.
Land and building. And in that registry, he had taken the money. And there is dispute between the
Are you builder or what?
building and the equipments.
Medical. Entire medical. Na?
Yes.
Entire medical building.
And also, the main dispute arose regarding lease deed. And that deed already been challenged in the civil suit.
Have you paid the entire amount?
Yes, already. And the dispute already been settled.
6 crore 7.
Yes, dispute already
7 lakhs. 7 lakhs.
That is.
You got back your money.
I file an affidavit to that effect, and I will also file the Wakalatnama. Your Lordship will call this matter.
Have you?
I pray, Your Lordship, I will call the informant to before this court, in virtual mode or physical.
I will not call. If you have settled the dispute, you come and tell. Why should I call? You have received your money.
I received back. I have to take the detailed instruction from you.
Okay. Issue notice to opposite parties also entered appearance and on advance notice, then undertakes to file in the Wakalatnama. Let count about the petitioner submits that the dispute is arising out of a monetary transaction and the civil suit is pending between the parties. Parties and they have settled their dispute and the disputed amount has already been paid to the informant. Issue notice.
Next week.
Put it on 7th, 8th. Yes.
46.
Private dispute matter. The present opposite parties filed an application under section 147 of CRPC. In that case, the present petitioner, who is the opposite party there, was directed to file the written statement. And the present petitioner appeared therein and filed an application as proceedings is not maintained on the ground that no document is filed and there is no schedule in the application. Then that application was heard. Maintainable application was had on 7/1/25. On that date, after hearing of that application, court without disposing that application, so much directed to the Tahsildar to demarcate the land. That order is challenged before Lordship.
Where is that order?
That is annexure 4.
4, huh?
Right.
Yes.
Annexure 4, 30 to 30, page number 33, last part. This court will find that a demarcation report of disputed scheduled land and passage road is to be collected from the Tahsildar. My submission, no application is filed, but a maintainable application was had. But that application kept in abeyance. But order was passed so much.
What is the prejudice causing to you?
My lord, my submission that actually the land in dispute belongs to us and other courtiers. Other courtiers was not implicated in this case. In order to harass intentionally someone in that locality filed this proceeding. And I was invited to file the written statement. If I was filed to the written statement, subsequently I will file this after this disposal of this application.
See, in a criminal proceeding, what written statement, what rejoinder, I don't know. On the basis of pleading, it will be decided.
My lord, in 147 application, only right of way which to be declared.
Where is that order directing you to move, file reply and all?
My lord, annexure 2. Annexure 2. There is a discrepancy. Though application was filed under section 147, the court initiated a proceeding under section 144. 2.
Yes.
And directed me to appear in proceeding under section 144(2) and directed the local police to submit inquiry report. In that case, I appeared. I pointed out as a proceeding under section 144(2), subsequently the order sheet became changed by the concerned PO. 35 copies with me. Then I pointed out the proceeding is not maintainable because no document is filed for initiation of proceeding. In respect of my land, status quo order is there. As I filed maintainable application, then the present opposite party filed an application for deputation of the penal commissioner, lower commissioner. Lower commissioner was deputed without disposing.
Is it the case that you have blockaged the passage?
No, my lord. Actually, the land belongs to me. In order to take my land, the case is filed without evidence, they want to create evidence either from the Tahsildar or from someone that
What is the prejudice cause? If
my lord,
demarcated, let it be demarcated.
my lord,
at least.
no, my lord, proceeding statute provides both parties will adduce evidence on the.
Don't bring technicality. You tell me you are agreed by the last part of the impugn order that this court opined that a demarcation report of the disputed scheduled land and the passage of road is to be collected from the Tahsildar. What prejudices you?
My lord, if so many land owners are there, including myself.
Let it be demarcated. Let us understand what
statute does not
Tahsildar is going to do it.
My lord, statute does not impart to the executive magistrate. My lord,
don't bring so many technicality into it. Come to the point.
My submission, how I will be prejudiced.
Tell me, how are you going to
submitting?
Yes.
Actually, there will be no demarcation because the only order is to submit a report in respect of who is demarcation case.
If the report comes, then you can very well tell that this is prejudicial.
Yes.
It may be beneficial to you.
No, why are you submitting? I will be prejudiced. Only order is there to submit a report, not to demarcate the land. If in naked eye, somebody will going to the spot, is there. There is a provision in 47(2). Executive magistrate can demolish the building during pendency of the proceeding.
You are bringing so many technicality into it. Okay.
My lord, not technicality.
Simply issue notice. Let us issue notice. Let him come. We will settle it. It's very small dispute. Unnecessary. You are painting as if it is a very constitutional issue.
Not my concern. My submission.
Small issue. A small passage is blocked. Let us understand. Let him come. Let him come. I am issuing notice. Let him come. I can't pass the expert here.
With due respect, that is a status order. That order will remain therein. I am not challenging. Only I am.
I'll set aside. If any prejudicial report comes to you, comes on record by the Tahsildar, I'll set aside. I'll get assistance from the Tahsildar's report. Let us. I'll settle it. Don't worry.
Stay of the further proceeding. I am not further proceeding. Mr. Report should ask.
Why further proceedings? Only the report has to come. Let it come.
No, my lord, there is a provision during pendency. Executive magistrate can order for demolition. Say basis demolition document collection report.
After 1 week, let the report come. After 1 week, yes. Let it come.
Notice to parties.
File the process immediately and I'll lease it next week. Yes.
Item 140.
You're waiting for which item?
47.
47 Kurla. He's already waiting.
Okay.
47. My lord, in this case, what happened? This case was before Learned District and Session Judge Kotak.
Yes.
I was conducting this case in a criminal division 181 of 2020. Due to non-appearance on 6/1/2025, this case was before Learned District and Session Judge Kotak. But due to wrong posting of date in the diary, I couldn't appear on 6/1/25. I have filed Hajira on 7th. I found that this case was already dismissed due to non-appearance.
When?
On 7th, I came to know. I inquired about it. When I came to know that yesterday has already been dismissed due to non-appearance.
You have not filed that order, dismissal order. Where is that?
Annex 2.
Okay. The case of the 2015 matter. What is this case is about?
This is a case, my lord. This case was before Leonard JMFC, but 138 NI Act.
You are the informant.
Complainant. I have
2015. This is pending. What is the check amount?
2 lakhs.
Huh?
2 lakhs.
What are you doing 2015?
Continue Korchi due to non-appearance.
Where is that proceedings?
So it annex.
You have filed selected proceeding, 2 proceedings.
Close he can close the case. This is
I understand, but why it is pending for such a long time?
For production of the accused persons.
How will I get it? Where from I?
Annex 1.
You have filed only one proceeding.
I have filed
2015 ରୁ 2015 ରୁ ଦୁଇଥର କା hearing ହେଇଛି. ଦୁଇଥର hearing ହେଇଛି.
hearing ହେଇଛି.
Where are the other proceedings?
Annexure 1 টাকা দেখুনাহাନ୍ତି close କରିଦେଇଛି. He cannot close, my lord.
I can't.
GRCO 326.
I understood, sir. This is a proceeding. You are relying upon that the proceeding dated 7/4/2022 proceeding, isn't it? Before that, any other proceeding?
সেটা এক্সামিনেশন চিফ ହେଇଥିଲା.
କେମିତି ଜାଣିବି?
সেটা ମୁଁ annexure କରିନି.
ସେଟା ଦେଖନ୍ତୁ ଅଛି ବୋଲି ଦିଅନ୍ତୁ ତାହେଲେ ତ ଜାଣିବି.
ସେଟା ମୁଁ annexure କରିନି. ସେଟା ସାର୍ଟିଫିକେଟ
ଗୋଟେ proceeding file କରିକି ଆପଣ କହୁଛନ୍ତି 2015 ରୁ 138 matter is pending. What has transpired from 2015 to 2022? It is attributable to you or attributable to the accused?
ଆଗ annexure 2 ଟା ये लॉर्डशिप में काइंडली नॉन अपरेंट डिसमिस कर सेटा चैलेंज करथिली रिवीजन रे बिफोर लर्नर डिस्ट्रिक्ट एंड सेशन जज ड्यू टू नॉन अपरेंस दिस केस वाज ऑन सिक दिस केस वाज बिफोर लर्नर.
I understand this much. I understand
6-1 वे से नॉन अपरेंस डिसमिस कर देले.
That is why I am asking. You filed revision there also you didn't go.
Restore ही
And 138 proceeding 2015 you filed. There also you have not taken step.
नहीं नहीं सेटार कोन ହେଇची ना प्रोडक्शन पे थिला प्रोडक्शन ने कहले
where from I'll get those things
82 83
why are you not understanding
82 83 CRPC से नीचे कोई
where from I'll get it that when the
annexure
when NBW was issued you tell me
लिखा है 16/7/2021 process under section 82 83 NBW was issued till date the accused has not been
simply adjourn it to after 2 weeks file whatever
no,
I don't understand how can I make you understand you don't file anything 2 proceeding you have filed and I have to infer everything.
No, I'm challenging here annexure 2 my lord dismiss करते non apparent dismiss ता restore ही जाओ.
Why should I do it? Why should I do it? 2015 you file a 138 proceeding.
No,
am I not at least entitled to see why for this proceeding is going on since 2015? Today we are 2025. 10 years.
2022.
2 lakh rupees check. You file a complaint. 10 years this is going on. Because of your fault or because of the accused fault, I want to know.
Your lordship may kindly give judicial restriction direction. All the 139 case pending for production of the accused person, production of the accused.
Where from I'll get this? Why can't you file the proceedings and see that? You may be correct. I am not saying that you are wrong. You may be correct. It may be unnecessary getting urgent. I may ask an explanation from the trial court also. Why this is pending? The statute says within 6 months it has to be over. 10 years. Can you imagine? I want to know whose fault is it. Is it magistrate's fault or complainant's fault or the accused's fault? I want to know that. You file only one proceeding. Place on record the other proceedings. Let us see, understand. I'm just giving you 1 week time. Bring the proceedings. I'll just look into it. And if necessary, I'll pass appropriate order against I'll ask the magistrate why this is happening. 10 years.
Record room को पठी देथिबे entire document. सेटा को डेट रे थिबो सेटा जाना पड़ियोनी. सर्टिफिकेट कॉपीटा बाहर करिया को डिफिकल्ट होलो.
Thank you that you have not asked me to go and collect the documents. Thank you very much for that.
Next week.
Next, yes.
Belgium item 140.
I'll take bail jump matters thereafter. The rest of the matter I'll after lunch I'll take. Because of that inauguration. Yes, it's right. Yes. Wait, 1:05 I'll have to go there. Within 5 minutes I'll.
Don't go 48 is covered your lordship judge.
I will take it at 2 o'clock, sir. Please wait. This bail jump matters actually they'll type it out.
Covered by your lordship judge.
Wait, I'll take it up at 2 o'clock.
Lord is sorry.
And all of you have to go there. Yes.
140.
NBW 30/7/2024.
And a bail, फटाफट tell
bail 21/10 to 19.
500, huh?
Page 15.
500, yes. 500. Next.
15 my lord NBW 3/3/2025.
Yes. Bail.
Bail my lord. He has written no bail my lord at all.
500.
116.
16, my lord, already warrant has been executed and remanded to custody. Their rejection has been challenged here. It is custody bail, my lord. It's true. No, just jail.
NVW order dated
My lord.
also sought to be executed.
Already
sought to be
executed, my lord.
Set aside, has also
Yes.
been executed
And remanded to custody. Bail has been rejected there.
petition has been taken into custody.
My-
Therefore, nothing survives.
My lord.
Yes, next.
117.
17, my lord, NBW 18/11/2024, my lord. And bail, my lord, in a BLAPL, this honorable court has directed enlarge on bail on 30/3/2022.
500. Yes.
118.
118, my lord, NBW 7/1/2020, bail 26/7/2011.
1000. Yes.
119.
20. Yes.
Here 4/9/2024, my lord, NBW, bail, this honorable court has directed enlarge on bail on BLAPL 5788/2022.
Okay, 500. Yes.
120.
120, my lord, NBW 10/12/2024, bail 3/1/2022.
500. Yes.
121.
121, NBW 12/2/2025, and there are two petitioners, my lord, different date. Petitioner number 1 on 21/12/2018, 2 on anticipatory bail 18/5/18, my lord.
500. Yes.
122.
122, NBW 38/2024, bail by this honorable court 11,1100/2021, by order dated 5/9/2022.
500. Yes.
123.
123, NBW 23/8/2024, bail 3/7/2024.
Okay, 500.
124.
124, NBW on 28/5/2022, anticipatory bail on 20/12/2013.
1000.
125.
125, NBW on 12/11/2024, and bail, my lord, on 35/2020.
30.
35/2024,
500. Yes.
by this honorable court in BLAPL number 5390/2024.
126.
126, NBW 3/8/2024, bail.
ABLAPL on
Okay.
13 of this.
Ada lekhinandi.
13.
2023.
Okay. 500. Yes.
127.
29/1/2025, NBW, it is a NI Act, my lord. Yes.
My lord,
Item 68, my lord.
item number 43 is a Belgium matter.
Proceeding because the marriage and child was born, Mila. Well, the stamp report has shown the effect that the name of informant should be deleted from the title.
Name has to be deleted.
Informant, victim, Mila, the standing error shows them. Standing error shows
Why can't you write only informant and finish it up? Where is the question? Mention it. Write down informant.
Informant is the father of the victim.
Right informant.
Only informant. All that.
Identity of the victim has to be, maintained.
That is there. Standing error of this code is also there.
Therefore, right.
Victim's name and particulars should be deleted.
Yes. You write informant.
I may be pardoned to mention,
Compromise
my
matter, my lord.
lord, I may be pardoned to mention, my lord.
Yes.
My lord, I have mentioned one CRLMC 1605.
Madam, mentioning, all these mentioning are at 10:30.
My lord, I have today.
No, at this time I will not entertain mentioning. Half an hour it will go unnecessary. The limited time, lot of matters are there. Yes. Tomorrow you mention. Tomorrow 10:30. Yes. 53. Yes.
Compromise matter, my lord. 92, my lord.
I'll take all the compromise.
Matrimonial dispute.
Yes. 42. Yes. 42.
Yes.
Yes.
That's highly affidavit, my lord. Joint affidavit.
Yes.
The informant also present, my lord.
376 2N, 376 3, 313, 323 IPC, my lord. POCSO is there, but it is covered by your lordship judgment.
Lordship's judgment.
I have checked my lordship.
They are married, huh?
Yes, my
Yes.
lordship.
What is the age of this boy?
25 and 23.
Okay, then. At the instance of the who is the informant?
My lord. Informant the victim.
Victim herself is informant or
Yes.
parents?
No.
Person.
After 7 years, it
Yes, given
by that
that.
time it was measured.
The instance of opposite party number 2, FIR number 2 came to the after charge sheet is filed.
That's it, not right.
The FIR is actually the nascent stage of investigation. At this stage, the petitioners have petitioner and opposite party entered into a settlement. The petitioner has married with the victim on when have you married?
27/1/2025.
27/1/2025. They have also filed a settlement deed which is part of Annexure 2. On the basis of the terms of settlement, the petitioner has approached the court by filing the petition seeking question for the entire criminal prosecution initiated against him by the opposite party number 2. Opposite party number 2 and the petitioner both are present in the court. Within that court. The parties have also filed a joint affidavit related agility 26/3/2021 entering their every either para 2 to 4. Para 2 to 4. The Samana the petitioners petitioner relying upon the terms of settlement and on the affidavit, the agreement of settlement. Rajinama is compromise deed case Annexure 2 to the petition submits that the case of the petitioner are directly covered by the judgment of this court in Rosalie versus so and that ruled out the recent judgment.
Fayuddin versus State of Orissa.
Commissioner is for this case and submit that the petitioner is 25-year-old and the victim is, what is the age of victim?
Victim 23.
Victim is at present 23 years of age and both of them already married, and to that effect the affidavit has been placed on record. In view of the fact that the parties have married and so as to save through their marriage, they approved the court for party of the property. Hence there is no legal impediment. The opposite party number 2 who is present in the court on query from the court submits that she is happily married with the petitioner. He has no grievance left against the petitioner and she joins with the petitioner seeking question of the criminal prosecution initiated by her against the petitioner regarding to the yes.
92, my lord, matrimonial dispute under section 498 and other offences, my lord. Dispute has been settled, my lord.
All of them are there.
My lord, both are present, my lord.
Yes. And now, what about other? There are
Other my lord, the mother-in-law and sister.
Allegation?
Allegation by lordship, they only assaulted. One page allegation they have filed. They have only assaulted and scolded in the filthy language.
Charge sheet filed.
Yes.
Charge sheet filed.
Charge sheet is not with me, my lord. It is a case of 2014.
May not be there with you. Has the charge sheet is filed or not?
They have given only the
Investigation will complete, my lord.
No, you,
But trial has not been.
I will not do like this. 2014 FIR.
My lord.
You don't know what is the stage. By now you might have been convicted also. I'll call
No,
you.
trial has not been.
You should tell what is the stage.
Yes, investigation has been.
How do you expect to quash a FIR of 2014 without knowing anything? Charge sheet is filed? I don't know. Except FIR, you have not filed anything. Settlement. What kind of settlement is this? Adjourn it after 4 weeks.
My lord, IA is there, can you stay, my lord?
Why should I say? You don't know what is the what? You tell me what is going on.
Lord,
Stay means what? Investigation is going on or trial is going on. You don't know anything.
no,
Stay.
trial has not been commenced, my lord. It not been commenced. I have already taken that instruction, my lord.
Now I asked you whether charge sheet is filed. That you don't know. Trial is not commenced.
No, that instruction I have taken
why
from
are you making-
today. Today I have contacted the lawyer.
You contact, get full instruction, then you make a statement.
Till
Very
then, no,
dangerous to make a statement without knowing anything.
till then, no course of action.
Now he was asking for stay of trial court proceeding. Now course, no course of action. Then ask something else, bail.
No, my lord.
He's not sure about anything what he's saying.
No, my lord, the charge sheet has already been filed, trial not yet started, my lord.
When the charge sheet is filed?
That copy.
See, 2014 FIR.
Yes, my lord.
yes.
The problem is if the evidence is going on at the advanced stage up to the trial, I'll have to look into all these things. I can't quash like this. I can't scuttle the trial, ongoing trial. Merely because you have compromised. Imagine a situation, the same complainant has deposed something there in the trial court. Today, he turn around and move an application 482. I quash it. What will happen?
That is too difficult, your lordship, to ask.
So I need to know what exactly this is. You please ask your client and get right instruction, and then after 1 week I'll put it. Okay.
Can you fix it?
After 1 week.
Obliged, lordship. Obliged.
No, take note of it. You are okay now, I'm taking on record. And both of you get the instruction come. And file a affidavit also. In stage of trial, whatever. Okay. Yes.
Obliged.
Item 1.
Miller, I'm challenging the overtaking cognizance, Miller. In the case of theft, Miller, initial the petitioner's affair was registered in unknown, Miller. For the after assumption of charge sheet, police submitted charge sheet against the petitioner of 414 of IPC, Miller. Approximately the entire order sheet, only cognizance taken, magistrate not issued any warrant against me, plus on every date, magistrate reminder the IO to execute the imbue, Miller.
Theft of motorcycle. The charge sheet has page 21.
The entire order sheet lost in the time period.
If you are absconding, what to do? Immediately will be issued. Immediately is not executed so far.
Then no order of imbue, Miller.
No, it's very good.
Actually, the entire order sheet, but the imbue not issued, Miller. But is the wrong order has been passed and
No, 12/2/2024, that's it.
yes, person.
What is your name? What is your name? Your name is?
Document 85/2012, Miller, the page 23. Thereafter, entire order sheet have not filed, hand over to the clerk document the entire order sheet. 85/2012, the IO paid for NBW. The PO is on leave, my lord. Thereafter, no such envelope has been passed, my lord.
12/2/24, the accused Chandan Das, the petitioner, has not yet been apprehended.
Yes, or no such warrant has been issued.
When the warrant was issued?
My lord?
The rule issued against the accused has not yet been issued.
Yes. Each date, on a court below, passed an order, warrant envelope not executed. But no such warrant has been issued, that is the person.
There the motion was handed over to petitioner.
That's what I-
This was of this one.
That's not allegation, not.
Come to the order dated 27/8/2012.
Yes.
Read it.
Other accused absconder issue envelope against him.
That the other accused is you.
Yes, my lord.
So why do you say that NBW was
There is
not?
no previous in order or envelope issued, my lord.
This is the order first NBW is issued. Thereafter this NBW is not executed as yet. Why are you taking?
No, this is only
Don't make
issue
misleading
envelope. No such order of envelope is there, my lord.
I have read it out.
No, this is previous order, that is executed.
No, that is the first NBW. Thereafter, all the orders are NBW issued earlier, not executed. Read the proceeding.
That's why, this is the.
Anyway, that is why my understanding is. What else?
So because of this, my lord, the petitioner could not surrender, my lord.
I'll stay the NBW, go and surrender.
Carry
Do
it.
whatever.
Carry it, my lord.
Oh, that parity is there. I'll record that.
Yes.
Last NBW is that is 16/5/2024. Give petitioner petitioner is one of the accused in the present case. The charge sheet has been filed in the present case on 24/5/2019, showing the petitioner is an abstract. The trial court this order I have custody. Trial court by order dated 27/8/2012. The charge sheet of 24/5/2012. 27/8/2012. The letter JMFC Soro.
Yes.
White order dated 27/8/2012. Issued the illegal register the petition. They say the NBW could not be executed. Therefore, on various dates, the trial court has recorded the fact that the NBW have not yet been executed. Eventually, where is that order? Eventually, on 16/5/2024, passed the following order. NBWA has not been executed for Chandan Das Adhikari, and the other accused are absent. Take this step. What is your name?
Chandan Das, my lord.
Other accused are absent and takes no step put up on 21/5/2025 for the production of the accused Adhikari. Petition is agreed by the states and is approached this court by filing the present petition seeking quashing of the entire
Order taking cognizance.
quashing of the cognizance order dated 3/7/2012 passed by JMFC Soro in city case number 19/2012. I am not inclined to entertain this petition at the stage of cognizance, particularly because of the reason that the petitioner has been absconding since 2012. At this stage, the counsel for the petitioner submits that on instruction submits that his client would be appearing before the court on or before 20th of April 2025 and to stop the available to him under law. He further submits that the other co-petitions have already been granted bail. It is open for the petitioner to move application for grant of bail on all the grounds, including the ground of merit, subject to petitioner appearing before the court on or before 20th of also and paying a cost of rupees 1,000 to Soro Bar Association. The execution of NBW issued against the petitioner shall remain in state till 20th of April. It is made clear that no further extension of time this form will be granted to the petitioner. Yes.
Some sort of disposal standard.
2012 NBW. Yes.
Item 6.
Your Lordship, item number 12, when IA was left out.
I was
Left out.
which item?
Item 2.
12.
12.
This item
6, let's say. 6 I called.
item 6. When item 12 will come, you tell me. It is done already.
Pardon, my lord.
I am not able to follow. Please tell me what exactly you want.
Your Lordship, I'm praying for.
I had issued notice.
Yes, my lord.
If you don't have IA, what can I do?
Pardon, my lord, it was my mistake.
Is there? 1 minute, hold on. Just see. Okay. IA 12 item. There is an IA, you have not pressed the IA when the matter was taken up.
It was my mistake, my lord.
What are you seeking in the IA?
Your Lordship, I am seeking for the stay of the further proceeding of the OHRC case number 1584 of 2024.
You make a request before the Human Rights Commission seeking adjournment because there is a doubt whether it is entertainable or not. Anyway, you move an application. He will request before he will make a request. The petitioner will make a request before the OHRC seeking an accommodation in view of the fact that the matter is submitted before the court. Yes. 6.
Much obliged.
Paper next week, let's see. Okay, adjourn on the request. 6.
36.
May I? Yes. Yes. It is the seeking passing of the cognizance order. Order of cognizance.
Charge sheet, man.
Order of HR6 emanating from the FIR number so on so forth. The Mr. Mishra, legal counsel for the petitioner, submits that even if the prosecution case is accepted as it is for the sake of argument, no case under section 306 is made out in view of the settled position of law, settled position of law. He has relied upon the judgment of this court passed on 29/10/2024 in CRLMC number 1890 of 2023. Ravindra Singh Chauhan and another versus State of Orissa and announced. Which paragraph? Relied upon paragraph 15 of the state. Each notice to I mark that paragraph. In the meantime, considering the question. Okay. Yes. 39.
May I please, your lordship? Lord, here, my lord, the petitioner is a branch manager of the bank.
Sorry,
But,
sir?
The FIR has been registered under, Lord, under Annex 1, pursuant to the, my lord, complaint case lodged by the informant of Petitioner 2, my lord. The informant of Petitioner 2 is, my lord, the guarantor to the loan availed by his wife, my lord. And, my lord, the recovery proceeding was, my lord, after the NPA, the recovery proceeding was initiated by the bank. And, my lord, the bank filed the original application for the DRP. It was decreed, my lord. And pursuant to the, my lord, by the recovery officer, during the proceeding, my lord, recovery proceeding, attachment was made. But to nullify the, my lord, all these things, he filed the FIR, a complaint case before the magistrate, and the FIR under Annex 1 was registered.
Who filed?
Well, the complainant who is the guarantor of Petitioner 2.
Guarantor.
Okay.
Well, she kindly have a glance.
You had availed the loan.
No, my lord, the petitioner is the manager. Against
Okay,
manager.
bank
the-
manager, bank
Yes,
manager.
Yes.
Yes, yes. I have, recently there was a judgment of mine regarding the bank manager.
This one. The Surface Act and
Same, surface and
DRP.
recovery proceeding was initiated and the loanee has
And the
filed.
allegation is the bank manager has forged the signature of the.
My lord,
All these things are armed.
Yes.
They have taken loan, the DRT proceeding has been initiated, what the bank of will do. Let us issue the instance of opposite party will do FIR number also. Registered against the petitioner. Elimination of the petitioner is also. The petitioner is the manager of Eco Bank, lender Eco Bank. The opposite party number 2, the was the guarantor to the loan availed by
His wife, my lord.
his wife, who is the principal borrower. Due to default in the payment up to the loan amount, recovery proceeding has already been initiated by the bank. And the petitioner, who is the guarantor, who stood as a guarantor to the loan availed by the wife, has filed the present case against the petitioner, who is the manager of the bank. This notice written in the meantime, proceeding before so and so is stayed. Yes.
48.
My lord, I have annexed a judgment by Annex 4, my lord.
Ready to ask one.
Already?
Annex 4, my lord, I have given the judgment, my lord. Here, your lordship has passed order, my lord, in case of one Vikas Kumar Jain and another arising of the same GR, my lord, they are the customers, my lord. The affair was registered, my lord,
Who
under
is
section.
Vikas Jain?
My lord, one of the co-accused, my lord. 7%, sir.
And what is the role?
Similar, with the present. Customer.
My lord, immoral trafficking act, my lord, affair was lost. 3-4, section 2, 3, 4, and 5 of the Immoral Trafficking Act. They were arrested and subsequently released on bail, my lord. 7 persons are found inside the spa, my lord. And
This is the.
and he is one of them, lord. Out of 7 persons, my lord, he-
You are also a customer.
Yes.
I am
In this
also-
spa.
Yes.
Okay. Let us see. Where have you said that you are the customer?
My lord, the entire petition I have written, my lord, along with the other
You are the
persons, my
customer
lord.
or you are the manager?
No, my lord, I am the customer. If your lordship will see the FIR, my lord, in the.
Where is the-
7% is.
Out of 7, he is one of them.
Yes.
Okay. Same the petitioner is one of the accused in FIR. The petitioner is one of the customer who had been apprehended by the police in the spa. Which spa is that? Which was that spa name?
H20 Spa and Hammam.
H20
Spa and Hammam.
H2O, H2O, spa and hammam. Hammam. The The two of the other co-equal persons, those who are similarly situated, and approached this court by filing the criminal MC number 3390 of 2023. This court, by the detailed judgment dated 9/2/2024, was the entire proceeding for them. The petitioner, relying upon the say judgment, seeks indulgence of this court for and paying for passing of the entire prosecution against him. Mr. Konda, and counsel for the state submit that indeed this is have you challenged this order? No. This is in finality. Okay. Submit that the judgment of this court dated 9/2/2024 passed in CRLMC number 3390 of 2023 has not been challenged by the state. It has been finality. The case of the present petitioner is directly covered by the judgment. Hence, the petition deserves merit. Regard being head to the finding recorded by the court in its judgment dated 9/2/2024. At para, which para?
Last param. That is paragraph 15,
Paragraph
15, my lord.
15.
At 266.
Page 66. Paragraph 15. Yes. First. Okay.
49.
Lord, this is a forcing of affair, arising out of arising out of a 1cc case, Lord, the petitioner is a seller of land. After 10 years, the affair 1cc case was instituted without contemplating the provision under section 154(3), Lord. So directly 156, 165. Now the your lordship kindly see the complaint application. Annexure 1, case 14, your lordship.
Yeah.
Your lordship,
Whether information has been lost before police or not?
no, Miller. No, Miller. Recent judgment, your lordship
Yes.
just your lordship has given. This is mandatory in nature. It can be.
Yes.
And the effect.
Yes, Mr. Konda, what to do? 154 has to be followed. Thereafter, 155 has to be followed. Thereafter, 156. Straight away, you can't invoke 156.
Whether the information has been lodged before the police or not, no. The answer is no.
Categorically, I don't. Petitioner is seeking quashing of the 1 CPS number 5783/2021, initiated by the opposite party number 2. On the ground that in the para 6 of the complaint, the complainant, opposite party has categorically admitted that he has not approached the police before resorting to the remedy under section 156 of CRPC. Hence, the uncountable petition submits that the complaint under section 156(3) was not interchangeable. However, the magistrate has, the SDJM Bhubaneswar has not only entertained the application but also passed a direction on the basis of which the FIR PS case number Bodagoda PS case number 34 of 2022 has been registered. Issue notice to opposite party number 2, written within 3 weeks. In the meantime, proceeding in 1cc number 5783 of 2021 pending before ACGM Bhubaneswar State.
The 50.
Beg pardon, your lordship. Beg pardon, my lord. After item number 39, my lord,
Petitioner
after
filed
item
I only pray for correct change of the nomenclature. CRLM CRLM I is pending.
The person was granted bail. Cancel bail.
Yes.
I is pending. I only pray for change of the nomenclature.
It is the nomenclature.
I.
It would be CRLMA.
CRLMA. Correct. No.
Okay. For the reasons stated in the application, the same is allowed. The present petition is directed to re, directed to change to CRLM. There is directed to reset before these people appropriate. Yes.
51. Beg pardon, Your Lordship. My Lord, after item number 39, the item number 48 called, Your Lordship. My item 43 may be passed over, Your Lordship. 43, Your Lordship. I have not appeared.
You know, it was called non-appeared.
In the first hour, my Lord, I'm before division bench, my Lord. That's why I can't appear. Maybe passed over. This
So
time.
why are you making a complaint then? If you're not there, not there. What to do?
Lord,
I'll give one, lease it after 1 week. Next week.
Great.
Okay.
It is only NBW order, my Lord. It is only NBW. I have not availed the bail, but NBW passed prior to the charge sheet.
Oh, cancellation of NBW. Cancellation of NBW.
No. Yes, Your Lordship. Cancellation. Quashing of the NBW.
When 43 code NBW. NBW cancellation कर दो यार. Okay. Allowed. You appear on 20th.
My Lord, Your Lordship, only I am praying the courts below. Your Lordship may kindly mention the courts below.
Okay.
Because my Lord, the matter is
It's all right.
for JMFC.
All right, courts below. Okay.
And my Lord, the matter is tribal by sessions.
Next cycle. 51. You are seeking more indulgence now. Yes.
51.
Yes.
51, my Lord. Or 308 extortion, my Lord. Now settlement between the parties.
Nobody is there. None appeals for the petitioner is the interest of the urgent after 3 weeks. Yes. 52. 3 weeks, let them. 52. Yes, sir.
52, my lord.
Yes.
Here the petitioner is Sri Hospital. But the background of this entire case is, a case is registered under 3048 on a complaint lodged by one lady. The occurrence took place, let's say, about a kind glance to the FIR.
No, it is against the hospital only.
Hospital.
Who is the real accused?
The interesting part, my lord.
Who is the real accused?
The real?
Who is the real accused?
There is no name in the accused.
How will you substantiate 3048?
Director.
No. So no name has been mentioned. That's why kind glance to page 12. Nothing mentioned. I'm coming. Lordship, go to turn to page 12, column 7. Treated doctors of AIMS and Sri Hospital. AIMS, Sri Hospital is accused. My lord, and that too very interesting part is, after this FIR was lodged 8 months after the incident, in this, what happened, sir?
What about the in-house inquiry or anything of that sort? Nothing.
All dropped. Even Honorable Human Rights Commission disposed of the application, saying that it is not a criminal negligence, medical negligence. Can I have a kind glance to the page 5, my lord? Para 6. Para 6. Page 5, para 6.
Para 5 of your petition?
Yes, ma'am.
Okay. Yes.
Quoted. In my considered view, the facts narrated above do not prima facie make out a case of medical negligence. What the complainant feels is not important. The fact narrated above rather disclose that all necessary steps were taken and yet the life of the patient could not be saved. It may be a fact that there could not be a proper diagnosis to know as to why the BP was very low. With all these allegations, the complainant may move the civil court for appropriate relief.
Maybe an error of judgment or what to do.
So, and Jacob's case is, my lord,
you are directly covered by Jacob.
Jacob matter.
He directly covered by Jacob. Because Jacob says that first inquiry, thereafter FIR. Not that first FIR, thereafter inquiry.
I'm fine.
Here the inquiry is done and exonerated.
And my lord, very interesting part is, after I filed this criminal application, a letter was issued to the hospital. This application was filed on 3rd. Letter was issued by the police on 14th March. And we'll go to seize your document.
The exoneration is on?
It was registered on 3rd.
And what happened? CDMO, anybody?
Nothing. And
anybody has made an inquiry?
No, nothing.
No inquiry. Then Jacob case. Take
Yeah,
it.
that's-
Right. Petitioner is accused in FIR number 27, allegation of petition. The complainants had also filed a complaint before Orissa Human Rights Commission, which was registered as the case number OHRC case number 2631 up to 2019. The Human Rights Commission, by its order dated 20/11/2019, has passed the following order. Page 5 of the petition, reproduce the reproduce part, italic reproduce part. Mr. Mahapatra, the counsel for the petitioner, senior counsel for the petitioner, also submitted that in the present case, there is no inquiry conducted by the medical authority. Hence, he submits that his case is directly covered by the guidelines postulated by the Honorable Supreme Court in Jacob Mishra's case. Reported in Jacob Mishra's case. Issue notice to opposite parties. Written will so.
Aye, my lord.
So written will so. In the meantime, proceeding before which court is that?
JNFC court. The city case is before JNFC court.
City case, yes. In the stay application, you have not said anything. Which court?
Actually, I got the certified copy of the FIR after I.
You tell me which court, which proceeding?
JNFC court.
Proceeding, which proceeding?
Only the FIR copy remains with
FIR
them.
is there.
Nothing, no proceeding.
No action, no inquiry.
Investigation is not
Nothing.
going on now.
No, except writing a letter to the hospital for production of document after.
Investigation is going on. Then what?
Beg your pardon, sir?
Investigation is going on.
No investigation.
No investigation.
Then what say then? What will I say?
The FIR is still pending.
I can't say the investigation.
No, my lord. Just have a kind glance to this letter. Kind glance to this. They are now.
In the application, you have not said anything.
We have stated that
Investigation proceeding in FIR number 2. That can't be done.
Pending also not mentioned.
pendency, there is no charge sheet as yet.
So therefore, what will I say then?
The lordship to the further investigation of the police to be stopped.
No, I will not say the.
Well, my lord, now what is happening, my lord? After 7 years, see the letter. With reference to the, I have to honor to report that Arati complainant presented written report alleging that there is unrelated death. Her son Ashish Dena is admitted to Sri Hospital, Lewis Road, Bhubaneswar for treatment. But after some time, Dr. Sri Hospital declared him dead. His mother is alleging that due to negligence of the Dr. AMS and Sri Hospital, All India Medical Science and Sri Hospital, her son had died. On this report, the above noted case has been registered and investigated into. Therefore, you are requested for further following documents shall be provided for seizure for the purpose of investigation.
Since the investigation is going on, no interim order needs to be passed in the present matter. However, Mr. Mahapatra is pointed out that on 14/3/2025, the investigating officer has issued a notice seeking seizure of original records. Seizure of original records. Seizure of original records. The petitioner, it is open for the petitioner to apprise the pendency of the present case in before this court to the investigating officer. Yes. This matter I can't see.
Let it be sorted at least so that.
Give it to, just up to 24. I have only said that you can apprise the fact that the matter is pending.
What happened, my lord?
I can't say.
After 7 years, somebody is writing a letter to the hospital to produce the document.
I took note of that. And,
Very
that's the
surprising.
best thing I can do.
Because third, it was filed, copy served on the government advocate, and it was communicated to the police station, and they simply said, write a letter. Because the pendant 468 comes as a bar, with the punishment is 2 years, no cognizance taken. That is still beginning.
Because you moved the application here and gave the advance copy, and therefore he has issued the notice. You must understand that.
So,
you have to say something. What action you have taken, I have given.
Hanging for 7 years.
Then 468 benefits directly.
That is what we have stated. We have taken the ground that also.
Yes.
Item number. Just pass over.
I have simply urgent for 1 week after 1 week. Yes. Notice is not a routine thing. Why notice? You have to make out a case, then only notice.
We have already made that compromise was there.
Compromise, huh?
I have mentioned in my.
What are the offenses?
Offensive 126, 115, and 296.
What are the injuries, anything? No. Simply issue notice here. 51 notice. Yes.
54.
May I please, Your Lordship? The Lordships have challenged the order dated 3/10/2024. Lordships may kindly look at page 19. This is a case, this is a complaint petition going on before the learned court below, Your Lordships, but the learned court below has given a date of 8 months. The statute itself says that a trial is to be conducted
What to do the pressure also, you know.
Your Lordships, 5 years they have taken for framing of charge. 2020 ରୁ charge frame ପାଇଁ date ହଉଛି, and previously at page 18, Your Lordships, 1 year 2 months ର date
I
ଦିଆଯାଇଛି.
know, but
Next,
this is the practical difficulty with the magistrate also what to do. Lot of cases.
Lordships, I pray for a direction to expedite the trial. 9 months ର date ଦିଆଯାଇଛି, Your Lordships.
Yes, right. Petitioner is the complainant in 160 case number 160 case number 291 of 2019. He submits that the complaint case has been filed by him on 24/8/2019. However, the trial is proceeding in the snail's pace, contrary to the statutory mandate under section 143(2) of NIA to
133 clause
complete the
3.
same within 6 months. 6 months. He seeks indulgence of this court at this stage and seeks directed for expeditious disposal of the complaint in view of the statutory mandate and contained under section 143(2) of NIA. The prayer made by the petitioner deserves merit. Accordingly, the SDJM Jajpur is directed to do well to see that the trial of the 1cc case number 291 of 2019 is completed as expeditiously as possible. From this observation, petition is taken. Yes.
55.
Obliged, Lordship.
Against the present petitioner at the time of charge, taking charge. The time of the petitioner were absent and another person was facing trial and acquittal. The Annex 3 is matter is amicable settled between the parties and between the.
What are the offenses?
My lord.
307. You have been absconding, what to do?
At the time of charge, sir.
Go and appear before the court. That petitioner is one of the accused in FIR number. Besides, how many accused total?
3 petitioners.
3 petitioners, huh?
Total 4 petitioners, one of them.
Petitioners are the accused in FIR number so. Besides, one Kalu Charan Samantara. During investigation, the Kalu Charan Samantara have been apprehended and he faced the trial. The learned assistant station judge Puri, by judgment dated 11/7/2016 in sessions trial case number 102/337 of 2015, recorded an acquittal in favor of the in favor of Kalucharan. Relying upon the state judgment dated 11/7/2016, the petitioners are seeking quashing of the entire criminal prosecution. However, fact remains that the petitioners have been absconding. Therefore, no leniency could be shown to them. The trial court has issued by the order dated to 48/2012, the trial court has issued NBW against the petitioners. Regard being had to the fact that the co-accused has been acquitted. This court is inclined to give limited indulgence to the petitioner by staying the execution of the NBW order dated 20th April, sorry, 20th August 2020, 2012 till 20th of April, 20th April 2025, subject to the petitioner appearing surrendering before the court, petitioners court, and resorting to the remedy available to the under law. It is open for the petitioner to move application or grant a bail on the ground that the co-accused has been already
ground of acquittal of the co-accused.
Okay.
Pardon me. I have phrase and post title, man. And the post title I have wrongly, JMFC Puri. Third edition Puri, man. File another post title, man. 17 file.
Surrender before third
17 third edition.
Third ADJ
Puri, man.
Third ADJ Puri. Surrender before the court of third ADJ Puri and before to the yes. Okay. Yes.
Ma'am.
The order dated 12/2/2025, my lord, wherein the petition filed under section 311 of CRPC has been rejected by the court below as 15, my lord, page 15.
Yes.
Relevant portion is page 17. I read it.
Yes.
Because, may I read, my lord? However, he remained dormant and was only filing time petition.
You are reading 17. Page 17.
Page 17.
Okay.
In addition to this, the learned counsel has submitted that some questions were left on which the learned advocate proposed to cross-examine the CW1. However, he has not filed the questionnaire in this petition, my lord. For that reason, it has been rejected, my lord. Along with the petition, a questionnaire has not been given by the petitioner.
You want to examine CW1?
Yes, my lord. Only it is a complaint case arising out 130 Act. For that reason, he wants to further examine the complainant.
2019 it is pending.
Yes, ma'am.
When the complainant was examined?
She was examined, my lord.
Where is his deposition?
He was examined on 2023 October, 16th October 2023.
23. When you move the application?
Application
what
was
says? Nothing is there in the.
It has been posted for accused statement.
It is recorded already.
No, accused statement has not been recorded. I am the accused there.
I'll have to issue notice without that I can do. Because you would have filed the certificate copy of the proceeding and all, I would have done it right now.
I have given the only order sheet, no, nothing. Only
the opposite party number 2 returnable within a week. Would a week for a level.
An adjournment petition maybe because it has been posted to.
I would have allowed right now. If you would have, if you have copies, give me. I'll allow right now.
Copies of?
With the cost of something. What is the check amount?
Check amount 3 lakh.
3 lakh. I would have allowed unnecessary these kind of petitions are creating problem here. Small petition. Yes, what do you say? You pay 20,000. Where is that item? 56. One single opportunity, 20,000. Yes, right.
10,000
order. Yes, see, you have not filed anything. Otherwise,
no.
Notice it will take 1 month, 2 months.
No, I don't want to take.
You pay 3 lakh rupees.
Only if 3 lakhs rupees nahi niche. I'm a fees. Sir, if your lordship is allowed 10,000 ki 5,000 kar dunga. 20,000 dei parivani se dei parivani.
Dei parivani. Check dei parivani.
Check actually check upon janchanti kete khetre diya idata hai kete kete diya hai.
Petitioner is agreed by the order dated 12/2/2025, passed by the JMFC Baripada in ICC case number 83 of 2019, whereby his application under section 311 CRPC for recalling CW
complainant.
complainant has been turned down on the ground that in the application under section 311 CRPC, the petitioner has not enumerated the questionnaires sought to be put to the witness.
The complainant.
Witness, namely the complainant, Mr. Mr. Vishwal and counsel for the petitioner submits that the petitioner needs only one opportunity to cross-examine the witnesses, and he undertakes to supply the questionnaires before the court below. On the date
For 7 days from the date fixed.
on the date to be fixed by the court. Since the petitioner is facing facing a trial for an offence under section 138 NI and presumption under section 139 NI operates against him, which is a rebuttable presumption, which is
given opportunity to adduce evidence 3 to 4 times.
Which is the rebuttable.
No. Accused statement.
Which is the rebuttable. Okay, 1 minute. Which is a rebuttable presumption. The onus of rebuttal. The onus lies against him to rebut the presumption drawn against him. Therefore, he seeks to re-examine the CW1, the complaint. Regarding head to the facts of the present case, I'm inclined to allow the prayer of the petitioner seeking the recall of the witness CW1. Accordingly, the trial court is directed to fix a particular date, and afford a singular opportunity to the petitioner to cross-examine
the complainant.
complainant. Before the date to be fixed by the trial court, the petitioner shall furnish the questions to be put to the witness sought to be re-examined. The trial court shall examine the relevancy of this question and summon the witness by fixing a particular date. The petitioner is also liable to pay a cost of 10,000 rupees to the witness on the day he appears before the courts for deposition. With this observation, the petitioner is disposed. Yes.
Yes, sir. Item 57, I'm praying for and short action.
Yes.
58. May I please your lordship? To 138 complaint. Complainant was examined and thereafter the accusers filed an application to permit him to adduce the evidence. That has been rejected. The lordship on to page 19.
You moved the application.
I moved the application for examination.
Where is that application?
That application at page Miller
16.
16.
Where is the order?
Order, my lord, the last page, 22.
22.
Start from 21. 2724.
Where is the last order? 22. No? 20.
That remains, my lord. He has filed the application, so also certain documents. One photocopy of the partnership deed has to be exhibited. It has been opposed by the complainant. The crux is, my lord, your lordship, may turn to page 19.
What are you, where is the partnership and all these things?
Kindly see page 19. That will clarify the order.
Yes.
My lord, while the defense has been produced for examination in part in case of the chief, at that time, my lord, I want to exhibit one photocopy of the some document, original documents, along with a photocopy of the partnership deed. That has been objected by the complainant. And in complainant objected that he has sought for an adjournment to file an objection to the petition 6/2/2000. There is no prayer to exhibit their documents.
No, your prayer is to only adduce.
Only adduce the evidence.
You have right to do that.
I have right to do that. He has
Why are
rejected
you
that
going to all
petition.
these things?
He has rejected that petition.
Who is appearing? Anybody is appearing?
No matter fresh admission. This is a brother and sister dispute. Both are related with each other.
Take out the notice. Second,
Okay.
second, third.
April, short date is
Third or fourth? Fourth. I'll allow it, but expert it doesn't. Yes. 59.
Yeah,
What is the take amount?
2,35,000.
Yes.
May I pray only one thing? Interim application was there.
That is the reason I'm giving fourth. You bring him.
Okay.
And why don't you settle your sister only?
If your lordship will send it to mediation, it can be settled there.
2 lakh rupees and you
2,35,000. 2 lakhs is only amount that he has paid. 35 years. Check has not been bounced. Check be bounced in. Check has refer to the drawer bank. Complaint.
You come with at least a lakh of rupees, I'll persuade her.
Mila.
Come with on fourth, you come with that money.
Mila.
Sir, come with that money and you'll pay and finish up. At least to show your bona fide, you come.
Mila.
Yes.
My lord, what happened when 6 months back, due to misunderstanding with an advocate in a traffic chuck, my lord. There 59, my lord.
What happened?
There was a case when petitioner went to the police station accompanying somebody, and as because some advocates came and pressurized by the local advocate, this petitioner became an accused. And his case was registered as a counter case, or case number 156, and though he had been to the police station earlier, and the person with whom he had gone, he was arrested and therefore released on bail. So, my lord, I pray.
FIR number 155, again, he has gone 156 because there, he is creating a problem in the traffic check, the advocate. That's why they abused him.
My lord, at that time there was misunderstanding. Now there is nothing, my lord. Because
why have you not implemented the informant? I would
Yes,
have issued notice.
My lord.
Implement, huh? Implement.
No corrective action in the meantime.
The informant issue notice, huh? To bring him. Who will see?
No corrective action in the meantime.
What are the offenses? What is
Offense, my lord, only 303, only, my lord, that is non-bailable. That is negala kagapatra gadi kagapatra negala. It's enough.
What? Nothing is going to happen. What is the stage?
They have only filed 161 statement.
What is the stage? Stage of the case.
Then charge sheet file again.
Stay money.
Police coach.
You don't know what is this? Bodhe nahi. Kaun to? Order has to be passed, not bodhe hite pare.
Say police search.
You tell me, how can I pass an order without knowing anything?
No.
Simply I am issuing note. No, I will not pass. I should know. I should know what is the stage.
And my lord, in connected case, earlier anticipated bail application was filed. Therein, he has been directed to be released on bail.
Must plead or say something that the matter is at investigation stage or charge sheet is filed. Which court it is pending? Which court it is pending?
Edgem Bhadra.
Thing is there.
I filed, my lord. And it's one series.
You take out notice within short date will be. Yes.
60.
While a petitioner has been issued NBW.
NBW date was 21/11/2024.
Yeah.
And the bail was granted on 21/3/2022.
I'm challenging order 21/11/2024.
Allowed. Yes.
61.
My lord, here, the daughter-in-law files the FIR. The marriage was solemnized on 13/12/2015. FIR has been filed on 7/12.
What are the offences?
My lord, your lordship will see.
498 and all.
Yes, yes.
I should note, yeah, I should note it.
And interestingly, the date the FIR was filed, the next day the wife has filed an application for divorce. Divorce. And
You are very lucky.
my lord,
At least-
sometimes it becomes unlucky.
No. You at least you will easily get rid of her. Now
But-
she has filed.
But,
You need not file.
but the other factor your lordships will then think.
You have to pay. You have bargained the risk of marrying.
My lord,
You have to pay.
father-in-law, mother-in-law, they're in Bangalore now for treatment.
Okay.
I pray your lordship may grant me interim relief of staying the further proceedings.
Let me move application for. Okay. Yes.
62.
My lords, in item 62, I beg to appear for the petitioner, my lords. I am being led by Mr. Abhijit Patnaik, my lords. He's caught up in election, my lords. I'm only requesting that the matter may be taken up before 4th of April.
Request for adjournment. Yes.
My lords,
I'm appearing on behalf of OP
before
number
4th
1
of
in item
April,
62.
as the matter is.
Appearing on behalf of OP number 1.
Yes. Okay.
My lords, the matter may be listed before 4th of April because it's coming up before the trial court on 4th. So any date before that, my lords.
We'll give a date. Okay. See. Don't fix the date according to your convenience.
Well, let's any date before 4th of April. That's all I'm asking.
Next.
64.
My lords, the next date, my lords.
He'll give a date for it. Yes. 64. No, maybe it's for the petitioner in the interest of justice. Yes.
65.
Same.
66.
Item 66, your lordships, and for the petitioner, I pray for an adjournment, your lordships, because Mr. Nanda is under.
The request is made on behalf of Santosh Kumar Hon'Ble, the council for the Yes.
67.
My lord, I have filed this application challenging the order dated 28/6/24, passed by the learned JMFC Polytechnic Dhenkanal in GR case number 325/24. The offence is under section 307 IPC. My lord, initially the case was registered under section 341, 323, 325 IPC. And during that time, the petitioner surrendered before the learned court below and was released on bail. But after completion of the investigation, the IO added section 307 of IPC against the petitioner. So the learned court below took cognizance of the offence under section 307 of IPC, including the 341, 323, 325 IPC. And in
Yes.
this case, my lord,
1 minute. Huh?
307 is there, my lord.
Added.
Yes, my lord.
Earlier it was not there.
Yes.
previously,
Registration is not there. And the injuries are grievous.
Huh?
Injuries are grievous.
Whatever. He is. He has been on. He was on bail.
Yes, my lord.
my lord.
He was on bail.
He was on bail before.
When the charge sheet was filed, when the bail was granted.
Yes.
5/7/24.
That's it, submitted.
When bail was granted,
There was granted. Previously, at that time, 307 IPC was not there.
5/7/2024, my lordship.
5/7/24.
Number 23, my lord.
and when the charge sheet was filed.
That's it, submitted, my lord.
Charge sheet was filed.
Charge sheet was filed on
28/6.
2024.
Huh?
Sorry, my lordship.
31/7/2024. Okay, right off. Petitioner is one of the accused in a fire number. So, he alleged offense under section 341, 323, and 325. Okay. The petitioner was enlarged on bail, admitted to bail by the trial court by the order dated
5/7/2024.
5/7/2024. Thereafter, on 31/7/2024, the charge sheet has been filed for release commission of offences punishable under section 341, 325, 294, 506, and 207 IPC. Well, the counsel for the petitioner submits that after the addition of graver offense under section 307 IPC, the bail granted, he may be taken into custody once he appears before the court, despite the fact that earlier he was he has been admitted to bail. The apprehension expressed by the petitioner, the petitioner may appear surrender before the court on the next date appearing and apply for grant of bail by relying upon the judgment of Sushila Agrawal and Prabhakar. Sushila Agrawal, Prabhakar. And with this observation, the petitioner is here.
Item 65, madam. Item 65. Leave to
I have adjourned it.
leave to royatli, my lord.
Adjourn it next week it will come. 140 matters are there. I can't wait. There are so many lawyers and senior counsels are waiting. Yes. Senior counsels can come, you can't come. I'll take it up next time. Don't worry. No, sort that. Don't waste time. 140 matters. Just imagine, everybody is waiting. I'll take it next week. 65, na?
65.
65, sort it. Sort it. Take. Yes.
68. May I please, Lord. In this case, the petitioner seeks to pass the FIR number 121 of 2023 of Chandaka PS. And the entire criminal proceeding corresponding to GR case number 605 of 2023 pending for the learned JMFC of Bhubaneswar.
Yes.
The offenses are under section 294, 420, 466, 467, 471 and 506 of the IPC.
Yes.
The matter has been, my lord, mutually settled between the informant and this petitioner.
Okay, I'll issue notice. Next.
69.
May I pray, my lord? Yes, my lord, multiple affairs have been lodged for the same offense by deliberately splitting the customers list. May I just place what is fact? If the complainant is a bank, ICICI Bank, it has lodged a report saying that it issued a credit card facility to some of its customers. Now, when that credit card remain unpaid, they made an inquiry to find out that one Torbez alum actually fraudulently provided their document, and through that document avails the credit card, and through that credit card being swapped against a few merchandise persons, and the money has been routed. That's their case. And in the process, they themselves narrate if between September 2023 to October 2024, all these 4 persons collectively have defrauded the bank to the tune of 2.75 crore through various customers. Now what they are doing, the exact affair, they are splitting the customer. In one affair, the value is there showing.
No, these are big scams.
7.
Yes, my lord.
7. No, what I'm saying is, I'm not saying that I should not be investigated. I am saying that I should be investigated. The consequence is that the Honorable Apex Court has laid down that all these things is to be merged and investigated in one.
That is not the scope of this petition.
Yes, my lord. That is the scope. I am not asking anything else.
See, you have filed only one petition.
Yes, my lord. I am only asking.
Quashing up the entire.
No, my lord. That is not the case, my lord.
Quash the criminal proceeding pursuant to the FIR.
Then it has to be go and it is to be merged with the first one. My lord, that is the law. Your lordship, that is
the law in 142.
No, my lord.
Supreme Court and get it.
No, my lord.
If you have cheated many people.
No.
I'm not. These are scams.
No, my lord. The law, the consequence, quite categorically, Honorable Apex Court in last 2025 itself the judgment. I am not saying that I am not going to be investigated upon, or charge sheet cannot be filed, or I will not stand trial.
Read your prayer.
My lord, that prayer, I am beg to apology that prayer is wrongly worded.
You are asking for quashing. I will not quash.
It has to be merged with the first one.
But where is your prayer?
That's wrongly worded.
You have to.
I have to correct it.
Merge with whom?
My lord?
Merge with which case?
Well, first case, first affair.
Where are the places?
No, my lord, that's.
You are trying to make out a new case.
No, my lord, that is no, my lord. This prayer is wrong. I have told.
You file a proper petition for that.
But I'll just.
Your whole case is For self-same allegation, there are many of them. It should be tagged. You are bringing Hon'Ble Goswami and all these things you will bring, I know.
No, Hon'Ble Goswami, Babu Bhai, that.
Hon'Ble Goswami, the recent.
TT
Goswami and now.
Surendra Singh Rathore and.
Ranveer Alavadia and everything you will bring. I know that.
That's.
But is this the scope of this petition?
Well, the prayer.
Go to right court and get the right order.
Prayer, I deeply
Right
apologize.
court to right court.
No, this
You are
prayer.
very fortunate that you have only cases in Orissa. I don't know, the some other state also you may be having a case. So you have a right place to go.
No. This is only happening here only. I'm not to go anywhere else. This is happening only here.
Let them find out, you might have done something somewhere else also.
No, I don't mind. No, I'll correct my prayer portion. Let them find out the issues.
After 2 weeks. Huh?
No, Lordship, because they are constantly filing one after the other affair. What I'm saying.
It is a big scam, I tell you.
No, I agree. That is a scam, and that the law has to be
And
clear.
every one of us are victim of this.
No, I agree.
If not victim, are vulnerable.
That doesn't make I authorize the law enforcing authority to use law.
Credit card is being used somewhere else.
Yes.
By the time you go out in court, pata chala account set.
Yes.
Everything said and done, my lord.
This is what.
No, that's all right, my lord. Everything said and done, but law has to be taken its own course. The way it is required to be applied, not that they can apply it.
You are more vulnerable than any one of us because your clients are very dangerous. You're coming to your office, just see. They may clone your fingerprint, they may do whatever.
I'm correcting my prayer only.
After 1 week.
70.
May I please? The petitioner, Mr. Lordship, challenging the order taking cognizance as well as the proceeding. Your Lordship, that in the meantime, matter has already been compromised. Compromise petition also annexed to this application.
You have committed all the IPC offense and now BNS, everything.
Your Lordship.
Also, what? Anything is left?
Petitioner number, may I submit your Lordship? Petitioner 1 and 2, the father of the accused. And the petitioner number 3 and 4, the father and mother of the victim.
And they have not lost the affair. That's why.
So we should.
May I submit your Lordship? In the meantime, ଯଦି ମତେ ବେଲ ଛାଡି ଦିଅନ୍ତେ ଆମେ compromise ହେଇଗଲାଣି affidavit ଦେଇଛି ୟା
I
ଦେହରେ.
issue notice it will solve many of your problems.
Yes, your Lordship.
Yes.
71.
My let us stay further.
Say I don't know, I can't say it.
My let us say that
Very complicated case.
order
I'll just issue notice, I'll give a short this thing.
cognizance.
If you can settle nothing like that.
ଆମେ ହେଲୁ ବାପା
Because the
ମା
offenses are very,
ପୁଅର ବାପା ମା ଝିଅର ବାପା ମା.
oh, well, anyway, complicated, very complicated. Yes,
71.
71.
My lordship, NBW case.
NVW.
Yes, ma'am.
Quashing of NVW.
NBW was issued on 24.
Yes, madam. Are you appearing? Yes. NVW issued on
24/12/2024.
24/12/2024.
Bail was granted on 28/6/2022.
21?
28/6/2022.
22. Yes. 500. Yes.
72.
On behalf of Achyutananda Patnaik, kindly taken up.
Petition.
73.
Lordship 73 kindly taken up tomorrow.
Not tomorrow.
Passover, Lordship, Passover.
Passover is not possible. Just see 4 o'clock Passover.
Oh, yes, ma'am.
Tuesday.
Any other day.
Simply adjust. After 1 minute. Yes.
Wednesday, Lordship.
74.
My lord, let it come next week or maybe.
My access on the said yes.
75.
My lord, date may be 92.
Yes.
75.
None appears. The interest of justice after 3 weeks.
76.
May I please, my lord? Well, crossing of the criminal proceeding, my lord. The affair has been lost by one of the victim. That pursuant to they have love affair, and they have for pretext of marriage, both of them are eloped, and the victim is 32 years and boy is 32 years, my lord.
Married or not?
No, they are not married. So married, I'm relying on judgment of marriage at page 29. It's only court, my lord. But the consensual lord, between the both the parties cannot consider offence under 376 of the IPC, my lord.
That's right.
Judgment is
But
quite.
other offences, what are the other offences?
Only the 376 2N, my lord. Nothing more than that.
Charge sheet is not filed.
Yes, filed, my lord.
Filed.
And cognizance taken, my lord, at page 28, my lord.
Yes, sir. Consensual. Notice. Notice I issue notice. Issue notice.
But in this case, for my lord,
I'll say the proceeding also. They're covered by judgment. Consensual thing.
yes.
77. Yes.
We're challenging the entire criminal proceeding. On the ground, my lord, one person has complained against me, my lord, that I have submitted a false document while appointing as a teacher. +2 certificate I have forged.
And got the job of teacher.
Yes, but I have already lost the job. But after that, when I have sought full under the RT Act, the certificate which I submitted before the authority, my lord, and got the
That is genuine. According
genuine, my lord.
And have you given it to the authorities?
Yes, my lord, I have given to the authority.
Have they reinstated you?
No, till date, my lord, DP has started, they have not.
Petitioner is accused in FIR number 24. He has been employed as a teacher.
Teacher.
The allegation against him is that he has furnished a forged +2 certificate.
+2 certificate.
+2 certificate while getting the job. On that basis, the FIR has been registered at the instance of district education officer. District education officer. Subsequent thereto, the petitioner obtained the information through RTI. From which university? From where?
RTI. From RTI, my lord, from the public education information officer, DPC Sonpur, my lord.
DPC Sonpur, huh?
My lord.
Public information officer, DPC Sonpur. The RTI information reveals that the certificate which is alleged to be a forged one is a genuine certificate. On the basis of the date document, he seeks intelligence of this court to Quashing of the FIR. Issue notice to opposite party number 2. Opposite party number 2 returnable so. In the meantime, proceeding before so is state. So and get the job first. This will be quiet.
I will
go and show it to get the job.
If your lordship
at least show this stay order. I'm proceeding, taking the proceeding. Go and give it to the authority. Yes.
73, your lordship, as urgent.
Oh, yeah. Urgent. One day you can't take so many relief.
No.
That is the reason.
Your lordship may fix it at fresh admission.
Yes.
1 week.
1 week.
Next week.
Next week, 2-3 days only working days.
Yes. All right.
78. May I please? Here I am challenging the order taking cognizance as well as the criminal proceeding on the ground of compromise, my lord.
What are the offences?
Offences, higher offense is 307, my lord. And I have also annexed all the injury reports. Injuries are simple.
I'll issue notice.
The lordship may fix up a specific date so that the parties will appear and to file a joint.
I'll fix a date. This petitioner is one of the accused in the name. The instance of opposite party number 2, the
opposite party number 227.
Who is the informant?
Informant is OP number 2. Amulya Behra is the informant.
Of opposite party
and 3 to 7 are the injured.
Came to be registered against the petitioners. The opposite party number 3 to 7 are the injured in the present case. Which the comes for the petition submits that they have settled with issue notice to opposite party.
Okay.
79.
Date will fixed for appearance.
Yes. 79.
Item number 75. I want to weigh.
I gave next week. Yes.
79 minutes may kindly be adjourned to next week.
On the request of we have a petition adjourned. 80.
Grateful.
Right, please, your lordship.
Yes.
Lordship, the petitioner, after availing the restructural loan of 8 lakh 4,803
chair cleared the EMI dues with interest till June 2022. That is more than 4 lakh against the said loan. Thereafter, due to severe technical defect, the vehicle kept idle, for which the present petition became defaulter. So the made request by letter to the opposite party number 2 to settle the defaulted outstanding dues with interest which was calculated more than the dues and to waive out the same.
Yes.
But without considering the grievance to the opposite party number 2, demanded of sum of rupees 6,83,317 with the additional interest at the rate of 3% per month till the date of recovery. Then the opposite party number 2 filed the case before the court of the Learned Metropolitan Magistrate, 15th Court, Kolkata.
Where is that case?
Lordship,
Where is that matter?
15th Court, Kolkata.
Yes. Yes.
Annexure 1, Lordship.
What do you want?
I want to issue notice to the opposite party.
The case is pending in Calcutta. How I can exercise jurisdiction?
Lordship.
You may have a good case, but this court doesn't have jurisdiction. 482, I can't exercise.
Oh, Lordship, not press this.
Right. And counsel for the petitioner seeks to withdraw this petition. The petitioner is seeking quashing of the CS /11694 of 2024 or the criminal prosecution pending in the court of judicial magistrate, 15th court, Calcutta. Calcutta. This court doesn't have jurisdiction. It's in favor of the petitioner, and hence the petitioner at this stage, the petitioner seeks to withdraw the petition. Thank you. Yes.
81.
Hon'Ble.
May I please? Lordship, the petitioner is the informant here. Petitioner filed registered a case 192 under annexure 2. Lordship, the opposite party number have
Yes.
yes. Then again 419, 420, 467, 468, and 471
Yes.
against the opposite party number.
You are against
So,
the cognizance order.
I'm the petitioner, Lordship, the informant.
Informant. What? How are you agreeing?
Lordship, opposite party number 2, I have registered FIR against the opposite party number 2. Subsequently, in course of the investigation, the police forced the petitioner to the opposite party number along with other petitioner, other opposite parties. Then Lordship, in the meantime, the opposite party number 2 compromised with the petitioner. Lordship, now the petitioner want to pass the FIR, which is pending before the
For the opposite party number 2 only.
only.
What about the other accused?
Others are not involved.
I am appearing for the opposite party, so I have entered appearance. The case is authorized also. He has filed an FIR where he has stated that in the petition that matter has been compromised with the opposite party number 2 and others have been aided by the police forcibly. So the
I issue notice letter. You file reply.
No, I have nothing to reply in this. He wants the proceeding against us will be maybe quashed. I don't want to proceed with the case.
But opposite party जाते हैं.
No. हम समस्त ପାଇଁ मैं सर करती.
समस्त ପାଇଁ.
हाँ से लिखित पर समस्त माने he doesn't want.
What the state is saying?
State
only do after taking instruction. Now on the basis of this.
If the complainant doesn't want
to proceed with it.
If he doesn't want to proceed with the case, then
cognizance has already been taken.
Already
Yes.
taken.
Now you have to answer.
No, you have to yes.
You have to answer.
Yes.
420 ର case ସେ ତା ପଇସା
Yes.
Compromise ହେଇଯାଇଛି.
Simply issue notice, check notice. Let us see. You got back your money. Got back your money.
He has to get the crop insurance. He has not told about the names of the other co-accused
Opposite
persons.
parties.
They have nothing to do. It is a politically motivated case. Somebody who has withdrawn the amount. He is not a party here.
We'll see. Get in touch. No? Okay. Yes. Yes.
Petition is a lady, my lord.
working as a headmistress of Haladia UG UP school, my lord, challenging the order of taking cognizance under section 138 of NI Act, dated 5/6/24, my lord, annexure 3, my lord. The check of the petitioner was missing on 18/10/23, my lord, by her husband Manoranjan Kotua while he was going in a motorcycle, hanging the bag of the in the motorcycle, my lord, and the same was missing, containing ROR of the land, checks, bank passbook, and he reported the matter at Remuna Golei outpost on 18/10/23, my lord, by station diary entry number 12 of 23, my lord. Thereafter, the check has been misused by.
Where is your reply to the notice?
Yes, my lord. After receiving the notice, my lord, petitioner filed a complaint case, my lord. Complaint case, annexure 5, page 31, my lords. The complaint case, 1CC case number 78 of 24, my lord. Thereafter, same was registered under section 336(3), 338, 342(2), 318(4.
No, it's all right. Everything is all right. But insofar as the demand notice under section 138 NI Act is concerned,
Yes, my
whether
lord.
you have replied.
Reply I have not given, but I have filed a case of cheating, my lord.
That's a different story. Then it has to be proved in the trial only.
Initially, station diary entry was made, my lord.
You can
This
leave
regard
evidence.
check number so and so was missing in 2003, my
So these are
23,
the
my lord.
probable defense. You would establish that in the trial only.
Thereafter, this case has been
See,
filed.
now, since you have not replied to the notice under section 138,
And thereafter, my lord, complaint case has been filed in.
thereafter you have done so many things. Maybe in afterthought, we don't know. That has to be established in the trial only. Once notice is issued to you, you should have put forth your defense. You have not done it. Then presumption will operate against you. And that being a rebuttable presumption, you have to face the trial and revert it. The straightforward jacket principle. You can't do anything.
My lord, you can issue notice, my lord. Notice.
Check amount?
My lord.
Check amount. What is the check amount?
Check amount 5 lakhs.
Then 20%.
5 lakhs. The son has been issued by the check has been issued to his son, my lord.
The check. Who has signed in the check?
My lord.
Are you disputing the signature?
Complainant came in contact with the son and husband of the petitioner for purchase of land.
Check.
Thereafter,
whether in the check your signature appears or not.
Check that is also disputed.
Then
disputed.
Your signature appears in the check. 138 NI Act notice you have not replied. Then you have to
It is also signature is also disputed.
Where have you disputed? Where have you disputed? You must be disputing in your mind only. You have not put it on record. On record, where have you disputed?
The record, my lord.
Rightly cognizance is taken. Then you can't help it.
Check was missing, my lord.
That is a probable defense, sir. That is a probable defense. I'll expedite the trial.
No transaction between the petitioner and
you have to prove. I'll expedite the trial.
And the opposite party.
Petitioner is
kindly issue notice, my lord.
No, unnecessary.
My lord, see, only notice may be issued.
There is nothing in the matter how can I issue notice.
Appearance, my lord.
Notice is not routine. 130 matter. Once I issue notice, you go and ask for adjournment. It will keep on going on.
Only notice may be
5/6/2024 in ICC case number 747 of 2024, whereby cognizance of offence punishable under section 138 has been taken against the petitioner, taking a petitioner. Opposite party number 2 has initiated the complaint case against the petitioner for having after issuance of notice under section 138 bracket small b of NI Act for the return of check amounting to 5 lakhs. Admittedly, the petitioner has not replied to the notice under section 138. Therefore, the Presumption under section 139 and I proper him. In that view of the matter, the no legal impunity is found in order taking cognizance of offense and the trial of the case is pending since 2000. The complaint case is pending since section 143 of NA mandate the trial to be concluded if possible. Mandate the trial to be concluded within 6 months. Regarding head to doctor, while not entertaining the petition, I direct the trial court to do and to see that the trial of the case is concluded if possible. It is open for the petitioner to move application before the trial court, raising all the points that has been raised in the present petition. If such application is made, it can be considered on its merit. You move on. Yes.
There is an interim application I have filed for staying of the order dated 16/1/2020 and 81 just before.
That time you didn't say, I forgot again, I have to go to that file.
81, if the further proceeding will continue, then we will. That is the whole thing.
Why have you not come? Why have you put for?
I have put for this.
I know you have.
I have asked this question to those.
I understood it.
I have that.
Instead of you coming, you are bringing complainant. I understand. Therefore, I am not giving take. If it was so, you should have come.
Yes, ma'am. Yeah, I have put this same question to them also.
That is the reason I am not giving take. I understood the moment he filed. It was none of your business. You should have come.
Yes.
See, yes, next.
83.
84.
84.
May I please your lordship? I am on VC lordship. Petition 6 for the quashing of the affair, White Purigat PS case number 269, dated 5/10/2024. In the meantime, the matter was amicably settled, and the informant have given an affidavit of compromise. And while the petitioner was on jail custody, and the matter was pending in the BLPL number.
What are the offences?
Offences under 115(2). Allegation is that he was parking the vehicle in front of the sub of the informant, and there was a quarrel between them and exchange of words between them. Then the informant sustained some injury.
In the iron pipe, you have
That is not in the iron pipe. Actually, he fell down and the head was hit in the iron pipe. So it was amicably settled between the parties, and he is already.
Settled doesn't mean that it will be was petitioner the instance of opposite of party number 2, FIR number 7 came to be registered against the petitioner. The investigation is over.
Yes, investigation over. Charge sheet is already filed.
When the charge sheet filed?
Charge sheet filed on
12/11/24.
Yes.
12/11/24.
12/11/24. Charge sheet has been filed on 12/11/24.
So while the
petitioner submits that the parties have settled their dispute, and they have also filed a joint affidavit which annexed 3 to the petition, issue notice to the opposite party. Yes,
Lordship, item 136 also same. One of the brother.
136 also same query tag for this. 136. Yes.
Obliged.
85.
85.
Lordship, here my lord's offense is under section 194(1)(a), that is Motor Vehicle Act. There is the period is that is the punish that is the only fine 20,000. This is the period is the limitation is 6 months, my lords. Here, I am placing before your lordship the prosecution report by page 12. Here the challan has been issued on 11/5/2023 and the prosecution report submitted on 8/11/2024 after more than 1.5 years. So it is barred by law of limitation under section 468 CRPC.
Show me the complaint.
Cognizance has been taken, my lords. That is page
Cognizance taken on
my lords 18/11/2024. 11/11/2024, page 9. Annex to 1 series.
Yes, 8/11. Huh? Yes. 8/11.
Limitation. Yes.
And when where are the other documents? You have not filed.
My lords, that is the prosecution report is there, page 12.
Where is that? Where is that?
Page 12, my lords.
Page 12.
12, my lords. Date of dispatch is in the front page, my lords. 8/11/2024.
8/11/2024.
And challan number and date is 11/5/2023.
23.
First column, my lords. Challan number, challan date.
Yes. 11/5/2023.
My lords.
And 8/11/2024.
My lords.
And the cognizance is taken on
18/11, my lords. 18/11/2024.
So the limitation
Is 6 months, my lords. The on 468, the only fine is concerned.
limited from which day?
From the date,
challan.
from the date of challan, my lords.
Show me date of challan or date of this dispatch.
Date of challan, my lords.
Show me the law. Show me.
I have quoted my lord 468.
468 is
Period of limitation, that is
not helping.
that is the date of challan, my lords. Prosecution, because they have to submit the PR within 6 months, my lords. So 6 months if the offense is punishable with fine only. So the date when the offense is committed, from that date it will be counted, my lords. That is 468 CRPC is only applicable plus 194 1A.
6 months for what?
From the date of
Where does it say that cognizance?
that is from the date of a prosecution report, my lords.
How are you interpreting it? Does it say that cognizance has to be taken within 6 months?
Yes, the cognizance will be taken within the 6 months from the date of the offense.
How
Offense committed, my lords.
468 doesn't use the expression cognizance at all. 468 CRPC doesn't use the expression cognizance. Where from you are getting that?
There is a judgment of this court, my
Show
lord.
me that judgment.
Yes, paragraph 17 and 18 also there, your lordship.
6 months, if the offense is punishable,
That is there, that
only.
in that case,
6
several
months
cases,
has to be recalled from.
several cases have been filed.
Show me.
There, my lords, the vehicle challans were dropped.
Where is that? Show me.
The paragraph 17, your lordship.
This is 468 is reproduced.
Yes. Section 468 is quoted next to your paragraph 18. Considering the above provisions of law, since the penalty under MV Act varies from 6 months to 3 years in respect of vehicle checking reports issued for offense where the maximum punishment that can be imposed is 3 years, but in meantime that period has already been over, forwarding such VCS to magistrate would be hit by section 468 of the CRPC. Therefore, no useful purpose can be served if at this stage the matter is directed to be tried by the court having jurisdiction over the same. So all the VC checking reports that counts from the date of the challan issued. And in that cases,
Where does it say cognizance?
that is dropped all the VC vehicle challans which are more than 3 years because maximum punishment.
Understand, where does it say that the limitation has to be reckoned from the date of incident to up to
From the date of the offense.
Yes.
That is the law, my lord.
No, that's what I'm trying to ask you. Show me the law.
You lords keep it to Monday. I will.
Show me the law. That's not the case.
No, that is from the,
468, the limitation prescribed, you can initiate the proceeding. It doesn't use the expression cognizance. That's the difference between 468 and the other statute.
Yes, your lordship, keep it to Monday. I'll
keep it next week.
I'm satisfied. Your lordship.
That's the difference.
No, that is several cases.
I
Now,
thought
my lord.
you are trying to tell me that in a special statute there is a limitation. If you are using general statute 468, then cognizance is not used there. So
Yeah.
you show me some law.
PR submitted after the one. Yes, I will satisfy.
Satisfied.
Yes, my lord.
Okay. I'll just adjourn for a week.
My lord.
Yes.
86.
Here of the petition will consider.
Yeah, this matter.
Adjourn. Okay.
87.
The victim is the petitioner is the victim and informant in connection with the Badambadi case question 196, my lord. In this application, the petitioner seeks for a direction to give protection, my lord, for adducing evidence, my lord. Date is fixed on 5/3/2025, my lord. And he is coming from Dhenkanal to Cuttack, my lord. And his life is at risk, my lord. There are 4 cases against the accused person is pending, my lord, in different court. And once occasion, my lord, the victim came to OPID court to adduce evidence, my lord. On that date, the accused also lodged an FIR, my lord. So the petitioner is difficult part of the petitioner, my lord, to adduce evidence, my lord.
Then that new law which has come, Protection of Witness Act and all that, you have to resort to remedy. What can I do? Shall I direct to the
I wish to deputy police station to.
Then have you gone there? Have you moved an application? You moved the application in the concerned court.
My lord,
Concerned court will take care
director.
of that.
Yes.
What can I do?
My lord, director.
Petitioner, the victim in the you are the informant also.
Also, my lord.
Petitioner is victim, informant in FIR number so. The matter, the trial of the case against the accused person, sir. Accused person is proceeding before the which court? Which court is?
Ad hoc additional session judge, first track court, POCSO 2, Cuttack.
He, the C or he?
C, my lord.
C is apprehending threat to life if he goes to depose against the accused person. Therefore, he has filed the present petition seeking the following relief. The petitioner is at liberty to move for appropriate application before the trial court to provide him adequate security and protection for security and protection while the deposes before the court in ST case number 326 up to 2022 with this liberty petition is disposed. Yes.
Madam, copy time course of the 5 तारीख अच्छे copy time.
Yes.
Oh, bloody.
89.
Right. And good against the present fiction, man. At the time of appearance before the after commitment, man. After commitment, the petitioner absent before the warrant
issued on 12
NBW issued on
against 5 emotion, 2 person arrested and released on bail, man.
12/12/22 date of NBW on the grounds of rejection of 317 petition.
28 to
12/12/2022. But my learned friend in prayer has mentioned 28/2012.
Second, definitely removable.
Prayer portion my learned friend has wrongly mentioned 28/2012.
What is the date, exact date? You tell me.
12/12/2008.
Where is that order?
That is your lordship.
Annex 1, my lord. 12/12/2022.
Page 7, your lordship.
The petitioner is agreed by the order dated 12/12/2022 passed by Session Judge Kendrapada in ST case number 186 of 2025, whereby NBW has been issued against the petitioners besides other 2 accused persons. The 2 accused persons have been apprehended and they are admitted to bail. Those who have been arrested, they are admitted to bail.
Already.
Apprehended persons to the NBW. Persons to the said NBW order. The present three petitioners have approached this court seeking indulgence against the said orders. On instruction, the learned counsel the petitioner submits that the will appear on or before 20th April and seek remedy available to the subject to petitioner. Each petitioner paying 500 rupees as a cost to the local bar. Local bar is Kendra Pradhan Bar Association. The NBW issued by the orders dated 12/12/2022. Execution date till 20th of April 2022.
Hey, partner, one mistake I have committed. Item 84, the date of charge sheet, I have wrong, really wrong date. That is actually 27/12/24.
Why are you adding confusion? Who has taken? See, these people are also getting exhausted, by the time. Many mistakes takes place.
27/12/24. Item 84. 27/12/24. Item 84.
Now, fortunately, yes, sir. Yes. 90.
91.
90.
Oh, 90.
I filed this case for quashing of the affair. As a
My learned sister was my tip. The case has been already been entered with an FIR also. Despite that, my learned friend is accessed for quashment. Ready FIR.
The final form has been filed. Why are you coming?
Page 15 notes. There is that present petitioner is added accused initially added as an accused, but a charge sheet has been filed as an FIR. Now
withdraw it.
But JMFC is absent, so we are unable to their waiver petition filing.
Madam, now the file form has been filed. So why are you aggrieved? Petitioner is, although the petitioner was arraigned as an accused in the FIR number so. However, after investigation, the final form has been filed on
23/1/2025.
Hence, the petitioner seeks to withdraw this petition. Allowed. Yes. 91.
May I please, your lordship? Petitioner allegation is he has purchased the stolen bolero. Lordship say in page 34, NBW was issued pursuant to the charge sheet file. Page 34, lordship.
34.
Absconded.
Where he is stated that he was absconded, but on the same footing.
Okay. Petition is agreed by the order dated 28/6/2022, whereby NBW has been issued against you are on bail.
No,
absolutely.
As the charge sheet has been filed against him, showing him as an absconder. Same Cordo on the second submit that will be on or before 20th of April, and she sought to the remedy available to him under law, subject to petitioner paying a cost of 500 rupees. The NBW issued on certain day is the execution of NBW issued on the date up till 20th.
Redemption charge sheet filed on 21/6 তারপরে ফাইনাল চার্জ sheet
28 তো লেখা না 2822
लेटेस्ट वाला करिया पड़ियो ना लेटेस्ट वाला
2822 লেখা না
sorry sir I don't think I can take up
If it doesn't come in conversation, your lordship can your lordship take it tomorrow? It's a simple matter of admission of NBW.
No, tomorrow I'll tell you. Tomorrow will be a very hot post thing because there are reference. There are so many other. To be safe, let it be on the second or third. You tell me.
You know, it's very simple matter of NBW being issued.
Which one?
98.
NBW. I'll right now do it. You tell me.
In a defamation case, we are under section 500.
I'll quash it. What is NBW? Go and appear.
Yes, and be released on bail because initially he issued a bailable.
500 complaint.
Yes.
How they will be getting bail? I'll say that.
Initially he granted bail warrant. That lawyer didn't inform and I was not aware, my lord.
500 bailable offense.
105, my lord,
Anybody deposing? 500 complaints. Defamation complaint. He was already in bail. Now NBW is issued. I'll cancel it and grant bail.
205 rejected, then bailable warrant issued. Then NVW.
Petitioner 88, na?
98.
Petitioner
Appear and be released on bail on any terms and conditions.
Yes.
that, the court fixed.
petitioner is agreed by the order dated 7/10/2021. Passed by the learned ACGM in case number 1201 of 2021. You are challenging cognizance.
I have challenged cognizance, but once I have filed a petition under 205, I don't think.
So what are you challenging?
I am challenging the NBW.
Then I understood. I understood. 1 minute. Whereby the cognizance of offense under section 500, 501 and 502 IPC has been taken against the petitioner. Apart from seeking, that's what you have written. Apart from seeking quashing of order dated 8/11/2024, whereby the learned JMFC2 Bhubaneswar has issued NBW against the petitioner. Mr. Mohanty, learned counsel for senior counsel for the petitioner. The petitioner was already admitted to bail in the present case, but for his default on.
But he was not admitted, my lord. He have filed a petition under 205.
Okay, he moved an application under
That was
205.
That was not pressed. Then bailable warrant was issued, then none was.
After receiving the summons in the present case, the petitioner moved an application under 205 CRPC, which was turned down by the trial court and bailable. Subsequent thereto, on 8/11/2024, the NBW has been issued against the petitioner. On instruction from his client, and Mr. Mohanty submits that his client will be appearing before the court on or before 20th of April 2025, and report will be readily available to him under law. Subject to the petitioner appearing before the court on or before 20th of April 2025, the NBW issue the execution of NBW dated 8/11/2024 issued by the Court of JMFC2 Bhubaneswar.
That would be
IPC case number 1201 of 2021 is stayed. It is open for the petitioner to move an application for grant of bail. Needless to say that the offences for which the cognizance has been taken, being the bailable offences, petitioner shall be released on bail once the APS before the court.
That would be on order dated 21/2025.
NBW order.
Yes.
No.
It was prayer you have written 8/11.
No, 8/11/2024.
8/11. 8/11. Yes.
Item number 141, my lord. Last occasion, your lordship gave the last chance to the London State Council to obtain the instruction. Still, he has failed.
I'll give last and final chance now.
Your lordship, item 133, your lordship.
I'll take it. See, hurriedly, if you do it, you will be at loss.
128.
Your lordship.
Next week, my lord.
128, my lord, extension of time.
My lord, item 111.
In this way, nothing could move, Nothing could move. Let us go patiently, then only you will do it.
I fight for stay of operation of the order expired order dated 23 passed by the additional district of Mexico State.
Am I taking up your matter? You are arguing unnecessarily. Hey, patience. Go with the system. Otherwise, nothing will happen. Small matter, I can do it. 1 minute, sir. Extension of time you are talking about.
128, my lord.
Extension of time. 128.
133, your lordship. Modification of order, your lordship.
Madam, please wait. I am taking up.
Your lordship.
128. Extension of time for what?
NBW.
For the reasons stated in the application, the time for surrendering before the court below has been directed by the order dated 10/4/2024 is extended up to 20th April. It is made clear that no further extensions are granted. Yes.
133.
128. It will not be heard.
133, Your Lordship, for modification.
Small matter which I can dispose of within seconds and do it. Where hearing takes place, then wait. Yes.
133, Your Lordship.
133.
For modification of order, Your Lordship.
Yes, what
Your Lordship
modification you
was
want?
directed to deposit the 500 rupees in Puri jurisdiction, my lord, because the case is arising out of Puri. But it has been mentioned as a Kujonga, my lord.
Kujonga?
Yes, Lordship.
The cost put 500. By the order dated 3/2025. The petitioner was directed to deposit the cost of 500 before Kujongo Bar Association. Puri.
Yes, Your Lordship. Either Puri or
Puri. Kujongo Puri Kordo.
Your Lordship. Extension will be granted, Your Lordship, because
of this confusion, the petitioner could not surrender before the court, and she seeks extension, extended up to 20th April.
Oh, bless you, Lord.
Item 129, extension of tax.
Yes, 29.
Yes.
129. Yes.
129.
What extension?
NBW is on
Deposit, cost deposited?
cost deposit.
Okay. For the reasons stated in the application, the same is allowed, and time is extended up to 20th April. Made clear that no further extensions are granted.
Item number 62, my lords.
60?
62, my lords. My colleague had appeared, my lords, and appraised the court regarding the.
No. I will not go reverse back. Yes, next.
My lord, item 103.
103.
I pray for my lord, let it come tomorrow, my lord, because due to default of compensation amount, not paying the compensation amount, the lady petitioner has been arrested, my lord, and then behind the bar. Her 4-year-old daughter is there, my lord. So your lordship,
Compensation of what?
compensation of 138 NI Act, my lord. 1,20,000 she has to pay within 90 days. She could not, my lord, deposit it because of illness, my lord.
Will you deposit?
Yes, I will deposit within 2 months, my lord. 120,000, 1,20,000 within 2 installments, my lord.
Total check amount?
My lord,
Total check amount?
6 lakhs. I have to deposit to 20%.
You come 20% of
20% compensation.
At least come with 10%. I'll release you on bail and.
My lord, from today onwards, in 2 months, in 2 consecutive months, I will pay 120 lakh, 1,20,000.
You deposit something.
My lord,
Come with 50,000 rupees.
I have to bail out from the custody. Then I have to arrange, my lord. I don't have any money.
What your husband is doing?
No, he's not doing nothing. Pan beetle shop, my lord.
Oh. Where have you said that you have a child?
I have about it, my lord. I have 4-year-old daughter.
Take it tomorrow.
Tomorrow.
But you give some to show bona fide. Give something.
Bona fide.
You are convicted.
Bona fide, that is there. Bona fide is that only 2 installments I will pay.
You are already in the custody.
Yes, from custody since, my lord, custody 11/3/25. 11/3/25 to custody.
Oh. Very unfortunate. I'll allow it. Do you have any objection? Oh, anybody? I'll issue notice, then it will take another 15-10 days.
Custody achi mur lekhi appointment. Order is there. My lord, order achi. Order, that is annexure 1, my lord.
Once?
Annexure 1. My lord, may I read, my lord?
I'll take it up tomorrow. I'll grant it.
Yes.
I'll take it up tomorrow. Take it up.
105 taken up to next week, my lord.
All the matters you will adjust to the
Yes.
next week. Do we feel it?